But again, my lord, I am before your lordship with leave of my lord, the Honorable Justice Apurva Sinari. My lord,
Mr. Bhattacharya, I'm conscious, single bench.
only prayer I am making is this to your lordship. But compliance report is already given to us, but that cannot be implemented unless the contempt is over. My lord, we are praying this. My lord, 3 matters are there. Maybe to be mentioned at 1:10 or 10 minutes past 1 o'clock tomorrow.
Yes. Very well. Sometime tomorrow we'll see, either at 1:10 or at 2 o'clock.
Grateful, deeply.
Let us see.
Grateful.
My lord, may I
Will
be
you-
permitted to mention My lord, may I be permitted to mention a matter? My lord, this is a contempt application. We are
This
praying.
bench,
My lord, this bench means, my lord, the initial order was passed in 2014. The
oh,
contempt.
very well, yes. No,
Uh,
but আমাদের তো সেটা নেই আর determinationটা.
Your lordship was one
I
of.
was a part.
Yes, my lord.
That দিন, okay.
Yes, my lord.
My lord, for correction.
কি আছে? না, এটা তো আমার কাছেই হবে.
Lordship, may I be permitted to mention for non-prosecution of
Non-prosecution to be mentioned tomorrow.
My lord, for correction.
Correction to be mentioned tomorrow.
My lord, may I be permitted to mention a matter for upgradation, my lord?
Why?
My lord, the court is lying vacant since long.
No,
I
sorry.
came, my lord, may I,
How long you have in custody?
my lord, 5 months, around 5 months.
No, sorry.
May I permit to mention on contempt matter, my lord, your lordship's bench, my lord. The appeal, the order was passed in appeal, my lord.
Sitting with whom?
Uh,
This bench.
This bench. Your lordship may be permitted to mention one matter, your lordship. This matter was heard on 13th of January 2025. This matter was mentioned as well. It's running in the list today as well, but it's running as item number 651, your lordship. I'm praying for upgradation, your lordship.
Why?
Because the petitioner's mother is very ill and have undergone through a surgery, your lordship. I'm left with a 10-year-old child, your lordship. This matter was mentioned 3-4 days earlier as well. Your lordship was pleased to make it in the list, and this matter was heard, and your lordship was ordered to make.
Mentioned tomorrow, yes.
Grateful, your lordship.
Mentioning for inclusion of relaxation
Give
of
it.
condition.
Your lordship, may I be permitted to mention a matter for upgradation?
Why?
The accused and the co-accused have been granted bail by this honorable bench. So the item numbers are 617 and
Therefore,
329.
because co-accused has been granted bail. No.
Madam, may I permitted to mention one matter for inclusion relaxation?
Inclusion.
Number 1.
Well, I beg to appear on behalf of the petitioner. The petitioner is in custody for a period of 2 years, 4 months, 22 days, my lord. Out of 11 witnesses, 1 witness was completely done and 4 witnesses only chief done. Now PW2 cross-examination is going on. 7 times prosecution is entirely took adjournment. 5 times they do it part and took adjournment. Now, out of 11, only 1 completed.
Have you seen the depositions?
Yes, ma'am. My lord, he is the man who bring the, my lord, commercial quantity of, my lord, LSD and MDMA and magic mushroom, my lord. My lord, prosecution already, my lord, examined, my lord, 5 witnesses, my lord. My lord, now we want to examine more or 3 witnesses, my lord. Total 11 witnesses, my lord. My lord,
5 plus 3 is 8.
My lord, they are the investigating officers, my lord. My lord, last, kindly see the last.
How many witnesses you will examine in all?
Total 8, my lord. There are 11 witnesses, my lord. We want to examine, my lord, 8.
My lord,
5 already, my lord, examined, my lord. they have filed application under section 231 subsection 2, my lord. For that reason, my lord, their the deposition, my lord, deferred, my lord. Cross-examination deferred, my lord.
Caesar witness has deposed.
Yes, my lord.
Huh?
Only chief was done, my lord. My lord, only one witness
Next date, my
complete.
lord, fixed, my lord, 31st, 30, my lord, January.
Last 3 days prosecution.
3 witnesses remaining? No.
No, my lord, one thing, my lord, I would like to bring your lordship kind attention, my lord. Only one witness completely done, my lord. Remaining 4 cross is remain. And remaining, my lord, nowhere in the report they says that
Who cross-examine those witnesses?
my lord, 231 was allowed by learned trial
Yes,
court.
you have the right to
My lord, last 3 days.
please
Yes, my lord.
to my question.
Yes, my
Then
lord.
you
Mail.
give answer.
My lord.
You have the right to file an application for deferment of cross-examination.
My lord.
But you cannot same time again claim that there is delay. Because this the deferment was done at your instance. We had
My lord, 11 times prosecution took adjournment. And my lord, nowhere report says that 8 witness they are going to examine. Kindly see once the report.
My lord, I have given, my
Why
lord,
to be mentioned? Why to be
My lord,
mentioned?
it was appearing in to be mentioned from
Ra-
Let it be listed under the regular heading, appropriate heading.
on my lord. On my lord.
On 6th February.
today I have submitted fresh report, my lord.
Hmm?
I have submitted today, my lord, I have submitted fresh report, my lord. Regarding, my lord, how many witnesses, my lord,
Which
examined,
report
my lord.
submitted
No
today?
copy, my lord.
Be at the state record. Let the matter be listed under the appropriate heading. 6th February.
Copy of the report, my lord.
Give a copy to him.
I have
Let
Well, let this matter be taken up on Monday, my lord, because last occasion, my lord, we submitted before your lordship that, my lord, defense witness is supposed to be, my lord, taken. I
No,
do not-
why to be mentioned?
My lord,
Yes,
since,
my lord.
my lord, I'll tell you, Lordship, my lord, the arguments were that there is a delay.
Of how long?
9 years, 3 months we were
Wow.
there.
So we filed a report saying that the arguments are being concluded. My learned friend said that the prosecution is taking adjournment. We placed on record an order sheet on the last date showing that the prosecution has completed their arguments and it is now the defense who is arguing and they took
I
adjournment.
see. When is the next date?
That I
13th was the next
I
day.
am lacking instructions.
On the
my lord.
prayer made on behalf of the petitioner, let this matter stand adjourned and be listed again on আজকে কি বার?
Today's
বৃহস্পতিবার.
Thursday.
Then it will
Thursday.
be Tuesday.
Tuesday, my lord.
Tuesday ডেটটা দিয়ে দাও।
Pleasure.
হুম, হুম।
No, so it was to be mentioned because mother of the petitioner was ill. Now on that score, report was last occasion filed by the state. Now this was adjourned last occasion because Lordship wants to know the how many witness they want to
Status.
My lord, I tender my apology. The report is not in form. Lordship kindly sees. They have stated 4 have been examined. How many they propose? My lord, I can understand my counterpart before the learned trial court is not cooperating with the investigating agency. That is why this kind of a report. They have stated 6 to 8 months will be required, but how many they propose? That they have not stated.
25 more witness yet to be examined as per charge sheet.
That they may not. That is what we wanted to know.
But that report doesn't disclose that fact.
How long you are in custody?
Because 2 years, 11 months.
তিন
And this
বছর।
is a clear case of 304. Because a thief was caught red-handed, beaten, died. So it can be a case of 302.
You cannot say so. 11 months almost.
Grateful.
Report filed by the state be kept with the record. Stop. We had specifically wanted to know how many more witnesses the prosecution proposes to examine, as is recorded in our order dated January 2, 2025. Stop. The report is silent on that score. Stop. Therefore, we proceed on the basis that all 28 charge sheet named witnesses are intended to be examined by the state, by the prosecution. Stop. Till date,
Only
four witnesses have been examined. Stop. There, hence, comma, there is no likelihood of an early conclusion of the trial. Stop. Paragraph. The petitioner is in custody for close to 3 years, few days short of 3 years. Few days short of 3 years. Stop. He cannot be kept in indefinite incarceration. Stop. The progress in the trial has been most unsatisfactory. Stop. It is anybody's guess when the trial will conclude. Paragraph. Without touching the merits of the case and solely on the touchstone of Article 21 of the Constitution of India, comma, we feel constrained to enlarge the petitioner on bail.
Great.
Deeply obliged, my lord.
ACGM Shialda, huh?
We also, Actor Atkuridi, we also notice that that a report dated January 13, 2025, signed by the additional officer in charge of the Narkeldanga police station, comma, is on record, which indicates that the petitioner's mother is seriously ill. এটা ঢুকিয়ে দিও।
Great.
Deeply obliged.
ACGM Shialda, huh?
এই তো।
For the petition, I'm not on the last occasion, Mr. On behalf of Mr. Sur, my lord, Mr. Sur was directed blood to comply your lordship's blood order that whether I'm on the standing on the same footing or not. And Mr. Sur said that one of the co-accused who has been granted bail is absconding. Lord, I can show from the order sheet that he was present in court.
There is no Passover, not today, chalo.
Lord, if it
Enough question. But item 446 also stands with the similar case diary. Another co-accused where I am.
Same case diary.
Same case. Similar
it's
set. Can it be
446.
tagged along with this whenever it is taken up?
Cannot be tagged.
Simultaneous. 446.
List করে দিও এর সঙ্গে Tuesday. Ensure his presence on Tuesday.
I cannot.
That is your client's bad luck. What can you say?
আমাদেরটা তো অন্য- I'm great.
Well, I will state. No, no. Well, this is the report, my lord, the petitioner gave birth to a female child on 14th of January. My lord, now she is admitted at SSKM hospital and post-delivery care is being taken care of, my lord. And my lord, as per the Alipur Women's Correctional Home, my lord, there are about 20 such babies, my lord, who are in the correctional home with their mother. So
Then-
no, there is no problem.
That is no ground for bail.
Yes.
So, may I say on merit also, Lordship, this is a case where the petitioner has been arrested on 14th of May 2024.
Sir, Mr. Shah,
Yes.
you asked for upgradation
Yes.
on this ground. This is no ground. We'll post it under the appropriate heading. On merits, we'll consider.
No, Lordship, what I'm saying, Lordship, I mentioned it because on 12th, 11th, because there was a date for delivery on 15th. Now, Lordship, on 14th in the wee hour, Lordship, she has given birth of a child. That's why I mentioned it. There was an emergency. That's why I mentioned it. Don't take me amiss, Lordship. Now, that was the medical emergency that propelled them to admit prior in hospital, and she delivered a child. Lordship, this is the scenario. Now she has delivered. So I am playing that his bail payer may be considered on that medical ground as well as on the merit also. So since it has been upgraded,
20 other inmates who have babies like this.
this is another consideration.
How long is she in custody?
Now 8 months.
ঠিক আছে, থাকুক. What are the charges?
What is the charge?
Charge sheet has been submitted.
20 kgs of ganja was recovered from
20
this
kg of
petitioner and
ganja.
2 others.
20 kg ganja.
20 ganja.
Just proceed the commercial quantity.
Joint possession or sole exclusive possession?
Joint possession.
How many accused?
5
The
accused
accused
persons.
two are still absconding.
5 accused
This
persons.
petitioner brought the ganja from Kuch Bihar. She was apprehended by the Shialda GRPS, and 2 persons were waiting there for taking the delivery of the ganja.
Medical care properly.
Interim pair. Interim pair may be considered, Lordship.
You have to consider.
At this stage, interim pair.
No, sorry.
Lordship, then Lordship, my pair will be considered on merit also.
On merit, we are rejecting.
Lordship, kindly.
Commercial quantity of
Also not
ganja was,
20 kg, Lordship.
Yes, that is commercial.
it's not commercial.
No, just commercial, Lordship. 20
Just
kg.
commercial quantity, right?
Sorry.
Just commercial quantity.
No, Lordship, sorry.
He je bole na, commercial quantity of ganja was seized from the joint possession of the accused persons, including this petitioner. Stop. In view of the restrictions in Section 37 of the NDPS Act, we are not inclined to entertain the petitioner's prayer for bail, at this stage. Paragraph dismiss kore dao. Paragraph. The petitioner, the learned advocate for the petitioner, says that the petitioner gave birth to a baby in SSKM hospital on January 14th.
She gave birth to the baby in the hospital, in the correctional home only. Thereafter, she was taken to SSK.
Which correctional home?
Alipur Women's Correctional.
In Alipur Women's Correctional Home on January 14, 2025.
Midnight.
Stop. She was immediately admitted to the SSKM hospital and is receiving necessary medical attention and aid. Stop. On the ground of birth of the baby, the learned advocate for the petitioner prays for bail. Stop. Paragraph. We are not impressed with the argument. Stop. We understand from learned state advocate that there are at least 20 other inmates in Alipur Women's Correctional Home who are similarly circumstanced and have babies. Stop. We direct the superintendent of the Alipur Women's Correctional Home to extend all necessary aid to the petitioner and the newborn baby and ensure that they are both taken well care of insofar as their health is concerned. Paragraph. Learned Registrar General is requested to communicate this order to the superintendent of the Alipur Women's Correctional Home.
Report be kept with the record.
Key report. The report,
Great.
Item 7. My lord, I am led by Mr.
The date fixed for charge. Not if your lordship be kindly posted on after 27, then it can be progress of the trial also, my lord, it can be.
আজ কি হচ্ছে 16 normally it would have come on the 21st. Now then let it come on the
This is under the heading top.
30th.
Yes.
Yes.
No problem. Grateful to you.
My lord, under the same heading, my lord.
Why? No, why was it listed under?
Yes, because my lord, I prayed for adjournment when my learned friend, my lord, said that he has difficulty on 2 subsequent dates. So your lordship was pleased to fix this matter under this heading.
Oh, this is POXO.
Yes, my lord.
Yes, ma'am.
না না পক্সোর দিনটা কবে হবে দেখো তো।
How long you are in custody?
My lord, 10 months I am in custody.
তাহলে টপ
Murder.
শোনো, আন্ডার দি অ্যাপ্রোপ্রিয়েট হেডিং ওই কবে 30, 29, 30 যবেই হোক, amongst the first 10 items.
Great, great.
After 30.
আরে শোনো না, গতকাল তো পক্সো ছিল, তোমরা এত না কি করো।
On 20. After post 30. Can it be post 30?
হ্যাঁ
Great.
Make please, Your Lordship. On 20th November, Your Lordship granted interim bail. And my lord, that 6th, 7th, and 8th January was the schedule for examination of witnesses. But the report so far as submitted by the state that out of 14, 5 only examined. And my lord, this is what happened. But ultimately, one witness was examined in part by the prosecution. They deferred. And ultimately, next date has been fixed on 17th May.
May?
17th May. But this is the progress, my lord, subject to lordship sanction, my lord.
So, my lord, the custody period was as per your lordship's last order, my lord.
See,
He was in custody for 1 year,
at the
1 year,
at the
7
instance
months.
of prosecution. And then, my lord, next 2 days.
He was in custody for 1 year, 7 months.
So we have to record that you did not commit the offense. That is the only problem. We have to record, prima facie, we have to record that you are not guilty.
Since we had filed a report
And, my
with your
lord, we
lordship.
have complied your lordship's direction. And, my lord, this is the progress, my lord. Your lordship.
1 year, 6 months, 7 months.
1 year, 7 months was the custody period on the date your lordship granted interim bail, 20th of November. We had filed a report that 6 out of 14 have been examined.
Whether they are responsible for a delay?
No.
But
No, my lord.
I don't have the order sheets.
So you will examine the remaining 8 witnesses. On 8th of January, the next date given is 17th of May.
Lordship confirms the interim order and puts him under the same conditions
Yes,
as
yes,
he
of course. Issue.
Uh,
Read order dated November 20, 2024, whereby we had granted interim bail to the petitioners in view of the delay in progress of the trial. Stop. Paragraph. Today, we are shown order sheets of the learned trial court. Stop. It appears that on January 7, 2025 and January is there here?
Case diary. The wrong case diary is given.
And January 8, 2025, although the accused persons were present in court, no prosecution witness was present. Stop. The next date fixed by the learned trial court is May 17, 2025.
So you just a minute. You assaulted the seizing officer 307, 332, 333, 326.
Injuries were also
not a
there.
wrong case diary. Din আমার ভুল হয়েছে. Is it correct?
Yes, yes. Injuries were also there.
Injuries 307 you attempted.
My lord.
No, you.
My lord, petitioner number 1. But your lordship considered the detention. My lord, now your lordship, my lord. And my lord, I submitted before your lordship, kindly consider petition number 1 was assaulted. He sustained injury. She was shifted to hospital.
You have no objection so far as this matter is concerned.
Or your lordship had already granted interim bail when these were already considered. Interim bail was already there on 20th of November. So that is why.
Stop. 8 more witnesses remain to be examined. Stop. It is anybody's guess when the trial will conclude. Paragraph. We are told that there is no adverse report as regards these petitioner insofar as compliance with the bail conditions is concerned. Stop. Hence, comma, we are inclined to confirm the interim bail on the same terms and conditions on which interim bail was granted, and we accordingly do so. Disposed of. এই order sheet গুলো রেখে দেবে on record.
And may I put that compliance so far as the one of the these are the diaries of the
1 year 9 months old.
Item 9 on praying for not today.
Item 10, same prayer, my lord, not today.
This, adjournment I am not opposing, but this is a matter, my lord, your lordship clarified for the report that why there was a delay. Charge sheet was filed along with the FSL report. But now he is praying for now. After filing, we have forwarded the copy of this. He could have answered to that.
Anyway, is
Anyway,
not in a position.
As kindly make it on similar from the next week, but may not be here.
Why then you are here, sir?
No, my lord, I have some difficulty. I am not feeling well, my lord. I shall leave.
Oh.
My lord,
When do you want it?
6th, my lord.
এই তা কবে হবে দেখ তারিখটা কবে হবে দেখো
First day.
6th of February পড়ছে পক্সো দিন পড়ছে না পক্সো না সরি
NDPS, my lord.
NDPS
Lords.
February Thursday. Today the Thursday, my lord.
হ্যাঁ ছয় 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 ঠিক আছে 6 February
Grateful to
শোনো শোনো এদিকে শোনো কৌশিক
High Court. ঠিক আছে চলো দেখছি
নার্ভাস হয়ে যায় আমি রাত্রি
সব একসাথে জয়েন করি
Item 11.
Lordship, I am appealing for the petition. Lordship, petitioner before your lordship is in custody for 3 years, 2 months. Lordship, from joint possession, 25 kgs gaja was recovered. 2 of the co-accused person were granted bail by this honorable court. I have annexed page number 8. Standing on the same footing, I am in custody for 3 years, 2 months.
Two difficulties, my lord. One, after the persons were granted bail, there is a rejection this petitioner faced before this honorable court. One difficulty. Second difficulty is that the petitioners who have been granted bail, the accused person, they are now absconding. They are not appearing before the learned trial court.
I am in custody for 3 years.
But Mr. Kesri, this Sheikh Azad,
He's on same footing, no doubt about it. But
delay, only delay.
difficulty is after they were granted bail, this petitioner approached this court and his prayer was turned down.
Where is that rejection order?
Lordship, I have annexed. That is also, but that was not placed.
Baba, which page?
Lordship, page number 10. Just after allowed order. Page 10.
Not discussed, nothing.
Nothing was
discussed. I
discussed.
understand, but thereafter the other
most
persons
pro-
are not absconded. They have absconded.
And this was 2.5 years ago,
Lordship, now I
October 22.
But
No,
that
no,
was
after
post.
that there is a objection.
What is the stage?
22.
Lordship, only
Kesri,
Lord,
Kesri,
My lord.
the rejection is of October 22. And the co-accused were granted bail in February 24.
no, Lordship, no. It is May 24. May 24.
Where, which
Page
one?
11.
To page 11, Lordship. Page
It will
11.
be page 10.
Lordship, pardon. Page 11.
Page 11 is that order sheet, my lord.
That is why I'm telling you,
This
Lordship.
was
Page
your
11.
lordship sitting with Justice Bishash, my lord.
But it was not
This was not placed before us.
no, Lordship.
These said orders were never placed before your lordships. That is why this order. But in any manner, my lord, the persons who have been granted bail, they have also absconded. They are
Lordship,
also not
any strength and condition, I will appear before the.
Stringent conditions were given to those persons
persons,
also.
and now they have not appeared.
They are absconded.
They are your friends.
Lordship, I am in custody for 3 years.
They were also granted bail because of long detention.
Yes.
And now see they have absconded.
Lordship,
You will surely abscond.
Lordship,
Issue.
Lordship, there is a in this order.
They have absconded.
Lordship, kindly call for a report then.
Let us do one thing. Let us place something on record.
Yes.
Because that might be.
If we find they absconded, we'll reject.
No. It is instructions. Instructions that we have received.
Lordship, in the allow order, it has been clearly stated if they abscond that their bail will be cancelled. They have not filed cancellation.
Now again, we will have to.
Lordship, that in paragraph 6, it has been stated.
Petitioner renews his prayer for bail, which was rejected on more than one occasion. And lastly, on May 22, 2024. Stop. He says that he is in custody for
3 years, 2 months.
For 3 years, 2 months. Stop. There is no possibility of an early conclusion of the trial. Stop. Paragraph. Let the state file a status report. Now, he further says, further says that 2 co-accused persons were granted bail on the ground of inordinate delay in progress of trial and long detention. Paragraph. Let the state file a status report indicating the stage of the trial. Stop. The report will also indicate how many more witnesses the state intends to examine and whether or not the other accused persons who have been granted bail are complying with the conditions of bail. List the matter when?
2 weeks.
6 February?
6 February.
Schedule date গুলো cover.
8 কবে?
This petitioner is in custody from 19th of June 2024. Nothing has been recovered from the petitioner. It's a case under 25, 27, 8, 28 and 29 of the NDPS Act. The first person was arrested. His name is Shafi Islam Sheikh. Pursuant to credible information, he was arrested from Howrah station when he was to board the Gitanjali Express for traveling to Mumbai. From Shahi Islam Sheikh, 4 kgs of heroin was recovered. Shahi Islam Sheikh disclosed the names of his associates. They are Guddu Sheikh and Suraj Sheikh. These 2 persons were at Baharampur. The investigating officer and his associates, they had been to Baharampur and then arrested Guddu Sheikh and Suraj Sheikh. From the possession of these 2 persons, another 1,012 grams of heroin was recovered. And they said that the person concerned who is considered to be the kingpin is one Amor Baga. Nothing was recovered from the petitioner. It is said that the bank account of the petitioner was credited with 12,25,000 deposited by Shahi Islam Sheikh and 7,50,000 by one Raju Sheikh, who is not involved in this case.
No, how did the petitioner's name come into the picture?
This is possibly not from the statement of the co-accused. Possibly. Nothing more than that.
How you have, what is the reason you have received 12 lakhs?
Because
12 lakhs rupees credited to your account or no? Or no?
But with regard to that, I have not taken any instruction if he wants.
You have received 12 lakhs. You have to.
No, that long before the incident, long before this transaction.
My lord, as per intel, a large quantity of contraband item arrived in Baharampur. And my lord, the consignee was escaping from Baharampur. My lord, thereafter, this Safi Islam Sheikh was deboarded from Howrah station, from Gitanjali Express. He was served notice under section 67. His statement was recorded, my lord. As per the leading statement of Safi Islam Sheikh, my lord, 3 persons were detained in Bahrampur.
The 2%.
2%, including Safi Islam Sheikh. My lord, that is Guddu Sheikh and Suraj Sheikh.
Huh.
From their possession, 4.095 kg of morphine was recovered. This quantity of morphine was in a parcel box which came from Nagaland through India Post. And my lord, the sender is this petitioner. His mobile number is there. That was verified. And my lord, we have collected the customer application form from the Airtel. And my lord, it reveals that this is the petitioner and he is the sender, he is the supplier. Prior to seizure, my lord, 11 lakhs were transferred in his account by this Safi Islam Sheikh.
This is the advance given to him.
My lord, advance given to him, and my lord, on 20th February.
So prior to arrest all these accused persons, advance money was given to him.
My lord, advance money was given to him, and my lord, on 20th February, just before one day, 1 lakh was transferred. And my lord, in this bail petition, my lord, if you consider, my lord, page 3, paragraph 3, my lord, the profession of this petitioner is a day laborer. And my lord, his account shows more than 1 crore 12 lakhs was credited in his account. And my lord, there are 3 criminal antecedents, and out of 3 in 1 Pete NDPS, he is still in custody.
Still in custody?
My lord, already charge framed, my lord, as per your lordship's order on 8th January.
No, Mr.
But I didn't know all these things. Very well.
The petitioner says that he has been falsely implicated. Stop. He is a daily laborer by occupation. Stop. He has no connection with the alleged contraband items. Stop. He is in custody since?
My lord, since June 2024.
June
2024. 19th June.
June,
my lord, production
19 June. June 19, 2024. Stop. He prays for bail. Paragraph. Learned State Council says that the consignment of contraband items, i.e., how many kgs?
My lord, that is, my lord, 4.095 kg.
4.095 kgs of morphine, was recovered from a parcel sent from Nagaland by India Post to Bahrampur. Stop. It has been ascertained that the sender of the parcel is this petitioner. Stop. This petitioner's bank account has been credited with huge sums of money contemporaneously, and the petitioner's account shows credit balance of over rupees 1 crore. Paragraph. In view of the aforesaid, there is prima facie sufficient incriminating material against this petitioner. Stop. Therefore, we are not inclined to entertain.
Only blood one humble pair. There are 31 witnesses.
Expedition. My lord, we will examine only 15.
Very well. General expedition.
My lord.
Dismiss kore dao, kore next. However, we request the learned trial court to expedite the trial to the extent possible and conclude the same as soon as it can.
Deeply.
Daily labor.
If I'm not today, my lord, join.
Yes.
If I'm not today, my lord, then it's okay.
কি আগে আমারটা না আগে তো?
হ্যাঁ আগে তোরটা আগে জন্য শামীম তোরটা পরে
14 and 15.
No, 14, my lord, is my application.
Yes.
Application for bail.
and 15 I am appearing lad in 15 there is a direction to file report.
We have taken up 14, Mr. Amit, just wait.
I'm for Union of India, Your Lordship.
In
Union of India.
14.
Yes.
You are not there in 14.
Yeah, in 14, my lord has been, the lordship's bench has been pleased to appoint us. Since
Union of India has been made a party here. Now on the last occasion.
Yes, we requested you to. Yeah.
I have received the report from the investigating officer. I have handed over.
আগের দিনের অর্ডারটা কোথায়? 10th January order আছে?
13 January.
13 January
আছেন তো বটেই।
কি দিয়েছেন?
What is the fact? More than 100.
Well, the fact of the case is quite disturbing because, my lord, I find altogether there are 6 accused persons and there is an allegation of intervention of the car, and from the car there has been seizure of 88 kilograms of ganja. The contraband article, it was coming from Odisha to the state of Bengal. My lord, this fact is really disturbing, my lord, when it comes so far our state is concerned. I have no issue with that, my lord. My lord, before I take your lordships to the before I pray that before consideration of the entire fact of the case, may I just take your lordships to page 6 of my application and paragraph 6.
You said no. There was seizure from this petitioner.
2 cars
My
were
lord,
intercepted.
Perhaps this petitioner,
The 2
he
cars
has
were
made out the
intercepted.
case. আমি একবার বলে দিই, my
Total
lord,
88 kg. From 1 car 60 kg. From his car 28 kg.
He was there in the car.
Yes, he was very much there. Yes, 2 cars.
At this stage, that is sufficient.
Yes, my lord, I know. But my lord, kindly
lord,
allow me,
25th
kindly allow me
February
to
is
place
fixed
on
for
record
evidence.
2 things. Only after placing on record, your lordship kindly
That's
decide.
it.
My lord, 2 points I am just trying to make. One is a report under the Right to Information Act from the National Highway Authority, which otherwise shows, I have annexed everything, which otherwise shows that at that point of time, the car which they are claiming that I was driving the car from where 28 kilograms of ganja was seized was not there. That is the report of a national authority which is of sterling quality. And my lord, this otherwise, my
Has to be of sterling quality because
Yes,
it
because-
supports your case.
No, my lord, this is because my lord, this has been obtained from the National Highway Authority. It's not a private document. And my lord, this otherwise gives rise to a suspicion, and the prosecution should come clean and prove the absurdity of this case, in my humble submissions, because, my lord, because of the 2 reasons. Because these otherwise gives me a right to at least, my lord, curtail my lord, so far the barrier under 37 is concerned.
Very well, that's your first point. What's your second point?
My lord, second point, I am just showing you lordships. My lord, the second point,
You are not there.
No, it's not that.
So it's a matter of evidence.
No,
matter
he
of
was not
evidence.
there, not issue.
My lord,
Issue
it is
is,
not a case. It is
according
not a
to
case, my
NHI
lord.
authority,
I being
they
the
obtained
officer of-
RTI that their car could not have been at that point of time on that toll plaza.
Yes.
Where from they were intercepted. Now, these are all facts.
Yes,
It has
yes,
to be
these are-
No,
adjudicated
these are all
first.
fact. My lord,
Let them, let it.
my lord, all I am trying to most humbly submit is that these are all fact. My lord, keeping in mind this is an alibi. Now the point is that, my lord, whether this alibi for the time being can be considered as a safeguard so far as section 37 is considered. Because, my lord, this is all I have obtained from the National Highway Authority. In the first place, because, my lord, from the fact I find that the seizure was done from Howrah. The time which is
You have the
mentioned.
seizure list.
Yes. And my lord, the car is shown that the National Highway report says the car was at that point of time crossing the Paschim Midnapur and Odisha border.
How will NHAI know that?
Because from the CCTV footage and from the toll plaza report, the NHI gave the toll plaza report. Because, my lord, in the toll, every time there is a CCTV and the report showing that when
The
this
seizure
car
list
is
shows
passing.
seal place searched. The column place searched.
Mr. Bhattacharya,
Name and address.
one second. Let him complete. Otherwise, this will never end.
Yes. Now, well, if your lordship so desires, I can stop here.
So what is your second point?
The
Indicate.
second point is, my lord, now the trial has started. After commencement of trial, my lord, only one, the investigating officer, he has been examined partly. The chief of this officer has been deferred. Thereafter, the prosecution, they have taken out an application under 231(2), my lord, praying for deferment of the evidence of the PW1, and they wants to examine all the eyewitnesses, all the witnesses rather, independent witnesses. Thereafter, they wants to again commence the trial from PW1. Now I am in custody for 2 years. It is not a case that I have. For last 2 years, I have been produced every day from the jail. I am a person from Odisha. I was driving the car as best, my lord, even if the allegation is considered. For 2 years, I've been produced from jail. Now they have taken out this application. This will take another 5 years to.
Can pray only on the ground of delay.
Very well, my lord, article on the touchstone of Article
We are not
21.
impressed with your argument on merits.
Very well. My lord, so far this is concerned, kindly considers, my lord, now it is not a deferment by me.
Only ground of delay.
Yes.
Because there is
My lord, may I submit on first scissor list?
No, no, don't.
Fine.
Not merits, delay.
Delay.
only on delay.
My lord, so far the 7th January 2025 order is concerned. It is really disturbing. I have nothing to hide, nothing to explain.
January
I can't explain this act. This altogether a bizarre act. No doubt about it.
Yeah.
PW1 is the investigating officer. Kindly visualize the scenario. PW1 is the investigating officer. He was examined partly on 7th January. Suddenly an application came up from the prosecution that there are altogether 6 witnesses in this case, 4 from NCB, 2 independent. Now PW1 is number 1, 2, 3, 4 NCB, 5, 6 independent. An application has been filed that let other witnesses be examined first, then I will examine investigating officer. Now, my lord, in my reading of CRPC and BNSS, I couldn't find any place where from this application fallen. My lord, as an officer of the court, I can't defend. But at the same time, only 6 witnesses are to be examined. The report says they took only 3 months' time. This is their undertaking. Kindly see the last page of the report. Last page in the bold, they said NCB is very much committed to finish the trial within a period of 3 months. However, it is spread before the Honorable Division Bench to direct the trial court for speedy trial in this case by preponing the next date of evidence on 25th February. Now, here another difficulty we are facing is the trial court, who is now in session over there, he is about to retire on January 31st. That is I have been told. Now, he is not very eager to take evidence since his superannuation is very near.
Sure.
So these are the situation. Now I beseech before your lordship to kindly issue a direction to trial court to conclude trial in terms of their prayer.
Only one court is there. Howdah.
Yes, my lord. Howdah.
Only one
One
only
court.
one entity.
One court.
We can withdraw and transfer.
No,
We cannot.
Only one special.
special court is only one.
Okay, let us see.
My lord, even if the deferment is done, even if the preponement of the date is done, then also, my lord, the examination of PW1 will be deferred.
Mr. Jana, what we can do at the highest, record their undertaking 3 months and dispose of this application today. You can always renew your prayer after 3 months. We will not say that, but you can. You are same footing?
Same footing, lad. Should I add one line if I can convince?
Yes.
Lad, Mr. Jana has already submitted.
Yes.
This
It
I
is
have
another
filed
car. It is another car.
this petition.
60
I have
kg.
already filed a writ petition also.
Yes.
They have also filed a report.
Yes.
But this differs. Lad, the NHI was a party to that writ petition also. Lad, they have also filed an affidavit. Lad, they corroborates my statement in the RTI application because it is my application, RTI, and they have replied. 3 cars were there. 2 cars were of us, and 1 of them were officers. And we were taken into custody at Balibhasha. And we were traveling in the officers' cars. not in our cards. Section 37, I have to satisfy your lordships that I am not a guilty, at least prima facie. Balance what 39. Now, here I have at least.
What is your profession?
I am a businessman.
Officer,
Now,
sir.
from Balibhasha to Amta, the
Maybe-
distance is 108 kilometers.
Businessman meaning what? You deal in what? Ganja?
No.
What?
Garments. And I am now at 70 years old. If I die without adjudication,
Within 3 months, you will not die. Within 3 months, you will not.
No letter.
And you cannot die without our permission. That will be contempt of court.
Now Hamim came up.
So far, I was arguing on the last occasion.
Some kind of emotional submission.
That from Balibhasha to Amta, the distance is 108 kilometers. Now, it will take.
Very good argument before the trial court. Go and argue.
They've got a really good case in trial.
Should I pass separate orders or combined order?
My lord, separate order because both these two orders need to be passed, my lord, separately. Since two accused, two CRM numbers.
Again, now it. Jono CRM NDP 1772.
Yes. Not for
The
your
petitioner says that he has been falsely implicated. Stop. He is a businessman dealing in garments. Stop. At the time of alleged seizure of contraband items allegedly from his car, his car was not at the place of seizure as would appear from report obtained from the National Highways Authority of India. Stop. He further says that he is in custody for about 2 years. Stop. None of the charge sheet named witnesses has been examined in full. Stop. Both on merits and on the touchstone of Article 21 of the Constitution of India, he prays for bail. Paragraph. Learned counsel for NCB strongly opposes the prayer. Stop. He points out that from the car of this petitioner, 26 kgs of ganja was recovered. Stop. He has filed a report signed by the IO.
He's in
the investigating officer of the case. Stop. The report says that
At the relevant point of time, he was at Balibhasha.
the report says that NCB is committed to finish the trial, conclude the trial within a period of 3 months. Stop. Paragraph. Commercial quantity of ganja is involved. Stop. The arguments of the petitioner that his car was not there at the site of seizure, can be advanced before the learned trial court. Stop. All factual aspects should be thrashed out before the learned trial court. Stop. Keeping in mind the restrictions in Section 37 of the NDPS Act, we are not inclined to allow the petitioner's prayer for bail. Dismiss করে দাও তারপরে লেখো. However, considering the period of detention of the petitioner, we direct the learned trial court to expedite the trial to the fullest extent possible, if necessary by preponing the next date of recording evidence, and to complete the trial as soon as possible, keeping in mind the commitment of NCB to conclude the trial within 3 months. Even next no.
Now, my lord, this commitment of NCB, my lord, that is fine. I have no issue.
After 3 months, you can renew your prayer.
My lord, in any event, when there is no judicial function, my lord, for any reasons or whatever reason, my lord, Mr. Bhattacharya has submitted, in that event, this commitment will not come into play. Because, my lord, they have committed, they say they fine, because the action on the part of the NCB is absolutely different and absolutely opposite from their commitment. They have taken out the application of development. Now they are saying we want
Come back.
My lord, please.
In item 15, only not 26 kg, but 60 kg. That is
60 kg.
in item 15. Well, report may be kept with the record.
Report kept with the record.
Well, I am for the NCB lordship.
এটাই বলছি একে দেখাতে হবে তোমার
For 52 years.
52 years. Oh, please take this. Yes, what happened?
On last occasion, can you see the order? Last order, my lord, as per your lordship, to submit the my lord, deposition copy, my lord.
NCB, we are appealing for NCB.
My lordship.
How many years you are in custody?
My lord, about 3 years, my lord.
About 3 years.
Yes.
On 13/12/2024, we have recorded that petitioner is in custody for about 2 years.
No, my lord.
Just 1
My lord,
month.
my lord, can you see?
1 month. 12/2024.
My lord, can you see the my lord?
Nitish Kumar or
My lord, the case started, my lord, on 4/3/2022, my lord, the case has been started.
Yeah, I'll take business.
Order of Friday, নীতিশ কুমার ঢুকে গেল।
He's in custody for 3 years.
4/3/2022, since my lord 4/3/2022, he's in custody, my lord.
400 kg of ganja.
Yes. My lord, during the pendency of the bail application, my lord, Honorable Apex Court pleased to grant bail.
My lord, we have already filed report in the last occasion. Lordship was pleased to further observe that why the prosecution is taking more than 45 days time to conclude the trial. So, my lord, the current situation is that out of 5 witness, 3 witness examination has already been completed. So, for 2 independent witnesses as concerned, we have already sent them summon, but they are not appearing. My lord, one has not turned up and other is not appearing. And there was court
What 6 steps? Next date evidence is 31/2025.
on that date, the matter got adjourned, lordship.
Why? You failed to produce witness?
Yes.
Yes, my lord.
Then
400 kgs of ganja.
Yes,
My
lordship.
lord, who accused is on bail, my lord, granted by the Honorable Supreme Court, my lord. Yes, my lord. Yes. Yes. Yes, kindly see the order, my lord.
No, sir, ওটা আলাদা।
আমি দিয়েছিলাম অনেক।
Yes, my lord. Lordship? No, my lord.
so far co-accused Mr. Safiquddin and কি নাম দুজনের?
Sofiqul Islam and
Refajul Islam and they are on bail and
Whether he has any criminal antecedent. Why you are? I'm asking her whether there is any criminal background.
no, my lord. There is no such instruction, lordship.
The status report filed by NCB find that 3 out of 5 Dutch named witnesses are declaring the trial is proceeding at its snail's pace as we recorded in our ordered December 20. However, learned counsel for NPP says that NCB is unable to secure the presence of the 2 independent witnesses, and that is why the delay. Whatever the delay does not appear to be for delay is not attributable to the petition hearing. They are in custody for
about 3
years. Paragraph being that the Honorable Supreme Court seeks to grant bail to 2 co-accused persons by order dated December 20, 2024, passed in criminal appeal number 5588 2024. On the ground of long incarceration of the accused persons. Paragraph therefore, we are inclined to allow
Shall not leave Kolkata. You are resident of Orissa. Yes.
Yes.
You have to
within the jurisdiction of Howrah.
Howrah. Why?
My lord,
Case is
pending before the
Howrah. Howrah PS.
Howrah PS.
Jurisdiction Howrah PS and shall meet the IC Howrah PS twice in a week. Okay?
Yes, sir. Yes.
Until further order.
My lord, grateful, lordship. My
কত টাইম নেবে 70
Well, I'm for the NCB.
17 lordship in this matter the father of the learned advocate on record is very sick and he is likely to be hospitalized today.
What do you want, Taylor?
I am praying for not today, lordship.
Not today?
Not today. Grateful, lordship.
Well, I'm for the petition.
Praying for Dr.
Why?
Lordship senior is unwell. He is unable to come to court.
Who's your senior?
Antarikho Basha.
He's unwell.
Yeah.
Grateful.
Grateful.
Can it be after 30?
After 13th, lekho tale. Accommodation is prayed for on behalf of the state on the ground that learned senior counsel is indisposed. Paragraph. On the request made by learned advocate for the petitioner, এই 13th এর পর কি ডেট হবে বলে দাও আমি 14 বলে দিচ্ছি, তারপরে আসুক লিস্টে, তারপর দেখা যাবে।
30th of January.
ও 30th, আচ্ছা। আজকে তো কত? আজকে 16, 17, 21 হবে আবার, তারপর 28, 31, 31st।
I'm for the petition. Well, I'm using the floor for Milord Bail, Milord. I have, on the last occasion, Milord, I submitted the report, Milord. It appears from the report, Milord, that on, Milord, out of 8, Milord, yes, out of 8, Milord, 3 have already been examined, and today and 4 have been examined, Milord, and today and tomorrow is the date fixed for recording of evidence, Milord. Today itself and tomorrow. 4 witnesses have been examined, and 2 other witnesses is scheduled to be examined today and tomorrow. So, Milord, out of 8, Milord, 4 examined, and 2 are going to be examined, Milord.
Shall we keep it next week just to assess
Yes,
the
yes.
progress?
But I can, but though my learned senior friend is so enthusiastic, my lord, to
No, I am not enthusiastic. It's my submission. What is
How long
what
are you in
appears?
custody?
my lord, near
What?
about 15-16 months.
No, Milord.
15, 16 months.
1 year.
Come back.
Yes.
Mr. Michael,
My lord, may I
please.
just only point out, my lord, there are 2 plots, 2579 and 2580. 2 plots, 2579, 2580. 2579 belongs to me, 2580 belongs to one Shima Bishwas. 2 plots. 2579 belongs to me, an abandoned house, tin shed. 2580 belongs to one's Geeta Bishwas.
Shima or Geeta?
Geeta Bishwas. I stand corrected.
Geeta is your wife.
No, nobody. It's a neighboring plot, nobody. That's a public toilet. From that public toilet, Ganja is recovered. Geeta Bishwas is not been made an accused. I have been made an accused.
How much Ganja?
Lord, 150 k, 159 kilo. 59.
And Milord, he notice were
No, no,
on.
please, sir, please allow me to submit.
When you were submitting on merit, then I have to say.
So please, let me
Earlier it was
finish.
rejected. Milord, earlier it was rejected, Milord.
But it was rejected, my lord. May I say this? It was rejected post the complaint was filed. Now, post the complaint has been filed, the charge sheet. It is, Lord, it's very surprising. They have taken documents showing that the plot from which the contraband was seized, it's an abandoned toilet. Turtles were found, an abandoned toilet, and public toilet from where the contraband was found, which is 2580 of Geeta Bishwas. Geeta Bishwas not an accused. I have been made an accused.
Mr. Bishwas, these are all factual issues.
Yes, my lord. Now I have prayed because of the examination of important witnesses have gone. Those important witnesses, the person who sold the plot to me has been examined, and he has told that the plot belongs 2579. Plot belongs to me, from where the contraband was not
Very well. Come back.
kindly
next week.
seize this. Well, Lord, I can come back
I'll
next
have a
week.
look
Kindly
at the
seize this.
earlier order of
From
Milord
where
rejection.
it has been
Detailed
seized.
order was
It is
Milord.
after it
was-
is after they have
Can I have
filed
a
the
look at
charge.
page 8, Milord?
This is a public toilet, my lord.
No.
Public
have a look
toilet
at
with
the-
5 doors.
By constructed by whom?
By Geeta Bishwas.
Under the control and possession of Milord.
Not prime.
Under the
kindly seize
control.
5 doors.
Under the Milord control of this petitioner before the Lordship.
যেভাবে তো মামলা শোনা
টিনের দরজা।
And Milord, kindly have a look at page 8, Milord. Detailed order was.
Back next week.
Details order was
I'll
Milord.
come back.
On merit, it was Milord
একসঙ্গে
rejected.
সবাই কথা বলবে।
That
একসঙ্গে সবাই কথা
that is the problem, my lord. My lord, whenever NCB appears, we do not get a chance to place our matter before this honorable court. Kindly see.
We are too.
Sorry for. Sorry, my lord. No, my lord.
Last thing appears also when he appeared for the
My lord, I got it. Your lordship
allegation
gives us
against
time.
the state.
Your
Allegation
lordship
against the
gives us
court. This is an allegation against the court also. My learned friends should.
My lord, I apologize, my lord.
I've taken serious exception.
My lord, I am-
Because the detailed order has been Milord indicated, Milord findings was arrived at Milord. That's it.
Yeah. You please allow them to place their.
But they do not think so, Milord.
We are told that 4 out of 8 charge sheet named witnesses have already been examined. So today and tomorrow are the dates fixed for examination of other witnesses. Stop. Paragraph.
Out of 8, Milord.
List this matter. once again on এই সামনের সপ্তাহে কবে আসে এনডিপিএস?
But Thursday is a holiday.
21st.
21st, kindly don't make it 21st. 21st, excepting 21st on any day. 22nd.
24th থাকুক।
24th.
24th Friday, your lordship will take it.
Then when 21st?
23rd is a holiday. On Thursdays, your lordship takes NDPS.
No.
Yes,
It's not on Thursdays. Let it be listed on 24th. We'll see.
I'm grateful. I'm grateful. In the meantime, my lord, I'll also collect the copies of the evidence. What has come against me, I'll place it with your lord. I'm grateful.
In the bail application evidence, your lordships will be examining.
রাখো।
In such a case, I do not know. Deep level.
20, my lord, I am for the petitioner. Well, this is section 50 recovered from pocket of the jacket. And my lord, not only that, the gazetted officer was heading this raid team. My lord, that is being reflected from the FIR as well as 161 of the said gazetted officer. During search, one polythene small packet was found in the left side pocket in his jacket.
How long you are
Is containing. My lord, I am in custody for 11 months, 15 days.
What is the stage?
Stage is this, my lord. The next date is on, my lord, 27/1/2025.
Permanent.
For, my lord,
NDPS.
examination.
No.
আমাকে এনডিপিএস বইটা দাও তো, ওখানে আছে আমারটা আছে। মারাট I do have.
একটা থাকার কথা না, ছিল তো। না এরা কিচ্ছু দেখে না।
দিয়ে দাও।
বাবা এখানে থাকলে তো আমরাই দেখতে পেতাম।
ওখানে নেই।
এই নিচের বইটা দেখো, সেকেন্ড বইটা, সেকেন্ডটা
NDPS. Yes, tell us.
My lord, I'm squarely covered by permanent judgment. My lord, on the last occasion, I have submitted that judgment also.
Joint communication.
my lord, permanent.
My lord, section 50 has been, my lord, kindly.
Here, my lord, section 15 has been complied. My lord, kindly come to my FI.
Have you read the Qasim's judgment? Have you read Qasim's judgment?
Kashif, my lord, I have read.
2024, it has been delivered.
NCB versus Kashif.
My lord, I have read, but I have forgotten. My lord, but my lord,
we are not forgotten.
no, definitely not valid.
No, it's important that you consider it, Mr. After that judgment, it becomes very, very difficult for an
My lord,
accused.
Kasif is by my lord D.Y. Chandrachud, Justice Chandrachud.
That's Kasim.
Bela
Nawaz Hussain.
Nawaz Hussain.
This is Justice Bela Trivedi. As recent as December 24.
Not one.
My lord, make it short passover. I'll come back.
No.
Either you continue or not today.
No. Not today.
Have you read? You have read?
Judgments, my lord, I have read, my lord, Paramananda, Nawaz, and this.
Nawaz is not applicable.
Kashif is the latest.
Kasif, my lord, I'll check and come back.
In this. Section 50 complied.
সরিয়ে রাখি না আবার চলে যাবে।
Yes.
My lord, there is a report, my lord.
What does it say?
My lord, it says that the petitioner is the carrier of the principal accused. That's why, my lord, she was present at the place of occurrence, where from, my lord, 41 kg 550 gram gaja has been recovered from the joint possession.
No. Regarding the status.
My lord, the report is status, my lord.
Child,
Oh, status, my lord, on 15th of January 2025, PW1 has completed.
Yesterday.
how many do you propose to? There are 20 charge sheet named witnesses.
Charge sheet, my lord, 20.
How many do you propose to examine?
That I have not taken into account.
That is exactly what our query was. Problem is you don't read our order.
No time.
Read our order dated 7 January.
I'm taking my apology.
Is it clear?
Yes, my lord.
Our query?
My lord. My lord, and the second query, my lord, you have answered. My lord, that is the place of occurrence. How, my lord, this, my lord, this is also a query. That is
That was not our query at all.
How long you in custody?
1 year, my lord. It is as a lady, my lord.
Sure. Is there any
No.
special?
No.
In CRPC, not in NDPS.
Come back with that instruction.
20 charge sheeted witnesses is there.
The এটা কি NCB নাকি? State. The state files a report which does not answer our query
My lord.
recorded in our order dated January 7, 2025. Paragraph, let a further report be filed on the next date
My lord.
answering our specific query, i.e., how many out of the 20 charge sheet named witnesses the prosecution intends to examine. Paragraph lists the matter 21st.
My apology, my lord. My unconditional apology.
Not today.
My lord, I'm led by Mr. Milan Mukherjee. I'm praying for not this week, my lord. Not this week, my lord.
Not after the petitioner, my lord. Not last day there was an order by your lordships. Or a report to be filed by the state with respect to status report. No charge has not been framed. Not my information is that the learned trial court is lying vacant due to the illness of the concerned learned judge. There are 33 charge sheeted witness. He is in custody for about 350 days. Earlier, she was granted bail on the ground of her illness. She was supposed to make a family. There was mishappening. Now,
You
for
filed
that-
report.
Yes, ma'am.
Tell us charge framed.
No. The learned
Charge has not been.
the learned trial court is
On
lying
the
vacant due to
earlier
illness
occasion.
of the learned judge.
How long in custody?
But about 350 days.
About a year.
About a year.
About a year in custody, charge not framed. Why not framed?
The learned court is vacant. Madam. This is my information due to
There are
illness.
total 33 witnesses. Lordship on the last occasion was they had it was rejected on 19/8/2024 by your lordships on merits. So, my lord, I argued that there is no circumstantial changes in the matter. The position of the accused persons remains still the same. She was granted interim bail because she was on her family way. Subsequently, she had a mishap. My lord, now she was again taken back into custody. Now they
Yes,
have renewed
surrendered,
their
madam.
prayer for bail. Now they have renewed their prayer for bail. There is no change of circumstances. On the last occasion, your lordship was pleased to.
Where is the rejection order?
My lord,
That
page
has been
33.
annexed there.
Page 33.
The last date was
30?
view of the honorable. Page 33, my lord, have annexed. Now, pursuant to that, she has surrendered.
My lord will
And
also
despite her
complete-
surrender, my lord, there is no change of circumstances in progress of trial. That is what, my lord, the last submission was made by my learned
This is
senior.
Mahesh Jaiswal. No? This is Mahesh Jaiswal, co-accused, joint possession. Your lordship has also rejected his application for bail. This is the order.
It's all very well, but what about the aspect of delay?
My lord.
My lord, 7 to.
Lord, kindly see the last order passed by your lordships on 7th of January.
7/2/2025 is the date fixed for consideration of charge.
They are in custody. Why you have not?
Lord, because Lordship will kindly see, I have made a list of dates. A list of dates have been prepared because her continuous absence of this present petitioner, charge couldn't be framed.
No, after she was taken into custody.
But I have surrendered
Yes.
pursuant to the action of this honorable court.
Surrendered. Post that, my lord, the date has been
When she surrendered?
Surrender 29th August.
My lord, my lord.
Then,
29th August she surrendered.
then after that,
My lord, after that, my lord,
Mr. Biswas, there is no answer.
copy on 5/10/2024, copies were supplied under 207. My lord, on 20, my lord, only 2 dates. 5/10/2024, 22/11/2021, 20/12/2020. On both occasions, PO was on leave. The prosecution was not at fault. PO was on leave.
So he's going to retire.
I have been informed that the next date is on 7/2/2025. I'll also get an information as to when the learned judge is sitting in the learned.
No, and I have been processed bypass surgery as
How many witnesses you propose?
33.
We have stated that we will try to close it within 20 witnesses.
It will take some more time.
Because
Let Mr. Gupta come back immediately after 7th February. Let us see framing of charge.
My information, I'm just placing before your lordship. The concerned judge is having bypass surgery and it will take time. And court is lying vacant for long due to the surgery.
may I say that?
But this is fact.
Prosecution has done everything within time. Every single thing within time. We are not at fault. The learned court below is vacant. My lord, we will take instructions whether.
Mr. Biswas,
My lord, I understand.
how do you balance it out? You are not at fault, we accept. How is he at fault? She at fault.
My lord, I understand.
If it is lying vacant, then that portrays one picture. He says his instruction is lying vacant. Take that instruction,
I'll
come
come.
back on the 21st.
21st of this month.
This month.
Completely.
The petitioner says that, read order dated January 7, 2025. Stop. Status report filed by the state be kept with the records. Paragraph, learned advocate for the petitioner says, on instruction, that the learned trial court is lying vacant. Paragraph, let the state obtain necessary instruction in the aforesaid regard and apprise us of the true state of affairs. Paragraph lists the matter on next date to 21 tarikhe naki 21st.
Deeply obliged, lordship.
I'll come up with the
21st amongst the first 5 items.
I'll certificate copy.
Amongst the first 5 items.
21st. Certificate copy গুলো করে নেব যে কবে থেকে কোর্ট ভ্যাকেন্ট এবং কবে
Court vacant.
It was last occasion, it was adjourned and your lordship directed for report. And my lord, on 10th January, 13th January, dates were fixed for recording evidence. None of the witnesses turned up. Total 13 dates have expired.
State of affairs. Now kindly see this report.
What
I mean,
does the
custody
report say?
Mainly BSF personnel are the witnesses. They are posted in different. They are posted in different places. Somebody has retired, so they are not coming up. That is the reason.
2 years, 3 months, 18 days is in custody.
Not a single witness examined.
Even the complainant has retired, so he is not appearing in the court after getting summons.
So what steps should be taken?
Status report filed by the state in terms of our order dated January 7, 2025, be kept with the records. Paragraph, we see from the report that not a single prosecution witness has been examined till date. Stop. Charge was framed on January 8, 2024. Thereafter,
13 dates.
13 dates were fixed. Stop. On 3 of the dates, the PO was on leave, the presiding officer. Stop. On 9 of the dates, no witness was present. And on one date, i.e. November 11, 2024, PO was on leave, PIO, presiding officer in charge, PIO,
Yeah, presiding officer.
presiding officer was on leave, and also no witness was present. Paragraph. The petitioner is in custody for about 2 years,
3 months, 18 days.
about 2 years, 4 months. Stop. There is absolutely no chance of early conclusion of the trial. Stop. In fact, trial has not even begun. Stop. Paragraph. Without touching the merits of the case.
But witness action has not begun. Charge has been framed.
Witness action has not, in fact, witness action has not even begun. Stop. Paragraph. Without touching the merits of the case and solely on the touchstone of Article 21 of the Constitution of India, we feel impelled to allow the petitioner's prayer for bail. কিছু condition দেবে তো দিয়ে দাও, কিছুই হবে না।
I'm grateful.
চলো ঘুরে আসি। এটা কত নম্বর হলো? 24।
My lord, item 25, I am praying not to do on behalf of Mr. Rudrodipto Nandi, my lord.
This is the fifth occasion. Also, let it be tomorrow under the to be mentioned or any heading. Lordship. This is the fifth occasion.
How long you are in custody?
Lordship, I am in custody for 4 years. Lordship, this is not a case of custody actual on the basis of. In this case, there are active. I was on bail in this. Lordship, if Lordship, one line answer. 135 days.
21st. Next day is 21st. Come back on 21st amongst the first 5 items. And no adjournment on the next date.
I was on bail. I was taken into custody in connection with another case.
In that case, you got bail.
Acquittal. After 5 years, I made prayer before the NDPS court to issue production warrant. No production warrant is issued. After I was acquitted, warrant of arrest, I made an application for revision. Revisional court pass a stringent direction. In the meantime, I was arrested.
Accommodation is prayed for on behalf of the state. Stop. Learned advocate for the petitioner is aggrieved. Stop. He says that this is the 5th occasion that adjournment is sought for on behalf of the state. Paragraph list this matter as a last opportunity to the state, list this matter on January 21 amongst the first 5 items.
Grateful. Also, I am for the petition. Lordship, in this case, on 6th of February 2023, this Honorable Court, while rejecting my prayer for bail, directed for trial to conclude within 1 year. Again, on 31st January 2024, this court rejected my bail prayer and directed to conclude within 1 year. Till date, as per my instruction, subject to correction by my senior, out of 6, only 1 witness has been examined. Charges was framed in 4th June 2022. I am in custody 4 years, 4 months.
Only one accused.
No, there are other accused.
They have absconded.
No, all are in custody. That is why charge was framed in February June 2022.
NCB report? Yes, ma'am. Give him a copy.
No, I have gone through.
Gone through it. What does the report say? Why the delay?
Well, the court was vacant now.
Then we'll have to let him go, Mr. Mondol. That is not his fault.
This is staffing, international staffing, Choros, 11 kg.
No,
Choros was.
Yes, he may be the worst criminal in the world. Tell us what to do. 4 years, 3 months. 1 witness examined, that too in part.
In part.
To what extent is he responsible for the delay? If you can show us he is responsible, no Article 21 benefit. কি করবো? এসো। Report filed by Narcotics Control Bureau, bracket NCB, bracket close, in terms of our order dated January 2, 2025, be kept with the records. Stop. Paragraph. We find from the report that there is that the delay in progress of the trial is not to any extent attributable to the petitioner. Stop. Stop. Only 1 out of 6 charge sheet named witnesses has been examined, and that too, in part. Stop. The petitioner is in custody for about 4 years.
4 months. More than 4 years, 4 months.
For more than 4 years, 4 months. Stop. There is no certainty as to when the trial will conclude. Paragraph. Keeping in mind the importance of a citizen's fundamental right to personal liberty and speedy trial, which ordinarily must override all other considerations, including the restrictions in Section 37 of the NDPS Act, 1985, we feel constrained to allow the petitioner's prayer for bail.
Grateful.
Stop. We also note that twice the court had directed the conclusion of the trial on an early date, but the same has had no effect. Paragraph accordingly.
If passport written, passport will be
Very well, passport, sir.
If any.
If any.
To be deposited with the trial court
And
before release.
And each and every day you will.
Those are
Yes.
there.
Yes.
No passport, if any, because I don't know whether he has passport.
No, international smuggler, you must be having.
He
must be.
If any, only if any. Grateful.
Grateful. ঠিক আছে।
যেদিন আসবে না নিম্ন এনডিপিএস সেদিন খেলা আমাদের এনডিপিএস এইগুলো এ করে রাখবে, হ্যাঁ, যেগুলো আর সিআরপিটা সবসময় থাকবে, সিআরপিসি আইপিসি তোমার বাস্তব
Item 27. 27, I am for the petition.
Well, before my learned senior friend starts, my lord, this item number 27 initially was tagged by your lordship with item number 1140 of today's list, my lord. And that was appearing as a specially fixed
You're
matter,
better.
on 2nd of January at 12:30. But on 2nd of January 12:30, there was an adjournment prayer on behalf of my learned senior friend, my lord. And your lordship was pleased to not to fix any time, my lord. And this matter is now appearing at different. Initially, it was tagged by your lordship, my lord. Pursuant to prayer made by my learned senior friend, my lord. 1140 of today's list, my lord.
Yes, Mr. Bishash, what is he saying?
My lord, there were two applications which were made specially fixed before the vacation. My lord, on 6th, 2nd, the matter was fixed. My lord, it due to my non-appearance, my lord, the matter was date was, my lord,
now what should we do? Tell us.
My lord, I am ready with my matter, my lord. Today,
1140 is whose matter?
My lord, it is
My
my
matter. I am for the petition in that matter, my lord.
both are accused.
My lord, both accused, one case, my lord.
You are ready.
My lord, only difficulty I am led by Mr. Lahiri in this matter, my lord. If your lordship can take the next date, my lord.
21st, can we keep these
My
two
lord,
matters
my lord.
together?
My lord, my lord.
No, you wait.
Next day.
The head of your
Or we can, yes, we can hear it.
change.
Proceed.
My lord. Deeply, my lord.
You are in 27.
Yes.
NCB or Union of
NCB.
Right. Two copies.
Ugruki.
Copies of the charge.
Office of charge sheet.
Complaint, my lord, as per NCB complaint. Yes, हमारा होता है.
No, Mr. Bishash, at this stage, very simple. Was there seizure from you?
Yes.
What? Of what?
Not ganja. My lord, joint possession.
How many accused?
4.
Joint possession, 30 kg ganja.
30 kilos and odd.
Why should we grant you bail?
My lord,
investigation complete.
my lord, no, my lord, your lordships were pleased to address, my lord, your lordships, there was a view upon your lordships by your lordships upon this Nawaz Khan. My lord, subsequently in October 6, 2023, another judgment was passed by the Honorable Supreme Court in Ranjan Chadda. Ranjan Chadda, the author was Justice Pardiwala. Ranjan Chadda, there were specific directions implied to be given, to be done when section 50, where Paramananda was also taken into consideration. Elaborate descriptions were given on section 50 and how proceeds for section 50 should be done and complied with by the investigating agency. Mandatory provisions were made in Ranjan Chadda. And in the last judgment in 2024, Kasif, well, it deals with section 52A. But section 50 has been relied upon in Ranjan Chadda, and an explicit view, a mandatory provision to be followed by the investigating agency in all sorts as is given. My lord,
If it is not followed, then bail can be granted.
my lord, it is said that all the documents and the seizures to become inadmissible in nature.
Would that mean that we can return a record of finding that the offense has not been committed?
My lord, if it becomes inadmissible, my lord, then the entire trial vitiates.
Other evidences, there may
No.
be other evidences.
My lord,
That is the Bela Trivedi, madam.
my lord, Justice Bela Trivedi is in Kasif. It deals with 52A. And this is section 50. I can provide the judgments if my learned friend so wants to come back on the next date. I'll take 15 to 20 minutes just to place that it is in Justice Pardiwala's judgment in Ranjan Chadda. The onus is upon the prosecution, not upon me. It clearly states that the onus is upon the prosecution.
No, only they have the burden to prove that seizure is correct.
And
if he is able to prove that seizure is correct, section 54, presumption.
No.
The stage of evidence, what will happen, nobody knows.
No.
If seizure witnesses
There may be
corroborates,
other-
then my lord, what will happen?
That I have understood.
No, that is it. My lord, this application, the first ground is, there are no independent witnesses. So there is no question of seizure witnesses. There are the RPF personals were the witnesses, and they were told from before.
Able to show that there is no scope to obtain the help of other independent witnesses.
It was from the railway station platform.
In the platform, my lord.
My lord, I will only rely.
Ground for bail under section.
My lord, there are.
We will allow you to place your
Yes,
cases.
I will, my lord. I will address
There
it.
is also judgments are also there.
21st,
Honorable Apex Court
which is an
judgments.
NDPS day.
Always
Yes.
police
At 4
persons
PM.
cannot be disbelieved.
At 4 p.m. 4 p.m.
Item number 1140 man.
Will be I should know 1140 টা এর ট্যাগ করবে না, এর পরেই দিয়ে দেবে marked 4 p.m. 15 minutes, Mr. Bishwas. 20 minutes and 10 minutes for you. And see, see what happens.
My lord, I will assail only 3 points. Then I know my fate.
Let this matter be heard, learned counsel for the parties. Stop. Hearing of this matter is likely to take some time. Paragraph. This matter once again on January 21, 2025, marked 4 p.m. Stop. Your item number is?
My lord, today's item number 1140.
আজকে 1140 নাম্বারটা দেখে নাও.
169.
Shall be listed immediately after this matter.
But the copies of the complaint will it be with your lordship?
No, take it back. Take it back. I have no intention of using it as a pillow.
এটাও তো খালি করে দিবি তো জেলটা মনে হচ্ছে এটা মাইলরকে এর সঙ্গে দিয়ে
My lord, Idul Miya, my lord, I am giving your lordship my lord dates.
রেকর্ডটা দিতে দে মাইলরকে
হ্যাঁ
record has not been placed
They are so fast.
so fast my lord. But on the last occasion, your lordship was directed to file a report whether supplementary charge sheet has been filed or not with the FSL. But FSL was not filed with the charge sheet. Subsequently, it was filed. It was subsequent filing. My lord, FSL dated 16/12/21, and my lord, last page of my report. And the
How long are you? 16? 16?
16/12/20. 20. My lord, date is
Well,
wrong.
if
My lord,
it's
it is not printed
March
properly.
24.
24. My lord, kindly see the at the bottom. My lord, kindly see. My lord, signature date. My lord, kindly see at the bottom. 24. It is Xerox. It has not been Xerox properly. Supplementary charge sheet dated 12 September 2020. 25th December 2024.
So charge sheet submitted.
Charge sheet submitted earlier.
This is
This is supplementary charge sheet.
But supplementary charge sheet along with FSL was submitted before the learned court below on 2nd January 2025. Specific instruction, my lord.
And you approached the learned trial court before
Much
that?
earlier. Much earlier.
Give us the dates now.
My lord.
Arrest.
I was arrested on 12th September 2023, 12/9/2023. Charge sheet was filed on 7/3/2024 without FSL. 180th day expired on 10th March 2024.
Yes.
Now, my lord, this rejection is on 8th November 2024. 8/11/2024. The 8/11/2024
And
because the learned court below which has been
And supplementary charge sheet is 2nd January.
2nd January, it has been submitted before the learned court below.
Hey, issue.
Supplementary charge sheet dated, my lord, can you record?
Very well. Dated
Because
16th.
because I don't know when that has been.
Dated 16th December.
16th December. That is also prior to letter to filing of the.
The petitioner was arrested on September 12, 2023. Stop. Charge sheet without the FSL report was filed on March 7, 2024. Stop. 180 days from the date of the petitioner's arrest expired on March 10, 2024. Stop. The petitioner applied for statutory bail before the learned trial court on November 8, 2024 on the ground that a charge sheet without chemical report is no charge sheet at all. Stop. His prayer having been rejected by the learned trial court, he is before us. Stop. Paragraph learned State Council tells us that supplementary charge sheet dated December 16,
No, 25th.
December 25, 2024, along with the chemical report, has been filed before the learned trial court. Stop. Paragraph. This case is squarely covered by our decision in the case of Idul Mia citation to the where we held that if the charge sheet in an NDPS case is filed without the chemical report, even within 180 days of the petitioner's arrest, upon expiry of 180 days, the petitioner becomes entitled to statutory bail. Stop. This is because in an NDPS case, a charge sheet unsupported by chemical report is not a charge sheet within the meaning of the criminal procedure, code of criminal procedure. Paragraph. We see that the petitioner in this case exercised his right to obtain statutory bail prior to the supplementary charge sheet and the FSL report being filed before the learned trial court. Stop. Therefore, we have to grant him statutory bail. Paragraph accordingly.
Depublished.
এবং যদি তোমাদের কাছে আসে মানে সাপ্লিমেন্টারি চার্জশিট along with FSL ফাইল করার আগে যদি 180 days যদি হয়ে যায় তাহলে তুমি citing
Idul Mia, relying on Rakesh sir, but মনে রাখো pending because of conflict of views. এটা আমরা Idul Miaতে discuss করেছি, conflict of high court.
On the last application, Lordship directed me to file report, Malad. May I please, Malad? দুটো কপি দেওয়া আছে। Five witnesses here, Malad. Two witnesses has already examined, Malad. And
2 out of 5.
Yes, Malad.
2 out of 5.
And 3, Malad.
And Lordship,
You also kindly see the last order, Malad. Report last page, Malad.
Report is totally silent about how much
is
time they needed as directed by your
Next
lordship.
date is what? 20th of January, Malad. Short date, Malad. 20th of January.
20th of January is
20 and 21.
After that, we'll keep it up.
Yes, yes.
Item number 142, that is for the same case diagram.
140?
এখানে তো কেস ডায়েরি থাকে না, এনসিবি থাকে।
Same case.
Co-accused. Oh, we'll also post that.
Yes, yes.
Report filed by NCB in terms of our order dated January 2, 2025, be kept with the records. Paragraph, we see that January 20
and 21st
and 21, 2025, have been fixed as the next dates for recording of evidence. Stop. Paragraph, as suggested by learned advocates for the parties, list this matter once again on a কবে হবে?
27 মালা
21 হলে 27
Monday.
27 to enable us to assess the status of the trial on that date, as on that date. আর তুমি এটা ঠিক পরে ওই 142 টা এর পরে দিয়ে দিও ঠিক।
Correct, fellows.
স্লিপটা দিয়ে দিন, স্লিপটা দিয়ে দিন।
হ্যাঁ পারে অ্যাপ্লিকেশন যদি লাগিয়ে দেয়
আবার
বাণিজ্যের ডেটে একটা অ্যাপ্লিকেশন লাগিয়ে দেয়
31, I am for the petitioner. Well, delay in trial. 39, 2023 date of occurrence. 4/1/24 charge sheet submitted. Total witness 10. April 24 charge was framed. Till date 1 witness in part has been examined. I am in custody. 39, 2023. 1 year, 3.5 months. Nearly 15 months.
We have framed the
Nearly
charges.
15 months.
Deposition has started.
One witness.
He wants us to go in a jet speed, my lord. My lord knows what is the situation in.
Before proceeding further, we give you a choice.
My lord knows trial court how they are.
Not yet. Article 21 stage has not reached.
The Lordship is pleased enough, kind enough to grant bail in other matters in 15, 16 months. My lord. Lordship will kindly consider it, but I am not going to the merits.
There are 10 witnesses. They may not even examine. Then we can call for a status report.
There, on the last occasion, your Lordship did call for a status report. Yes. Yes, ma'am.
কি বলছো নিয়ে নেবো
All are police witnesses, my lord.
নট প্রেস করছি না প্রেস
না খুব বেশি প্রেস করছি না
come back later if come back later
report dili na
na report we have not called for a report.
Oh yeah, not called for it.
Not pressed.
Let me come back after some time. Well, there was a direction. First, file a status report.
Hey,
Paragraph 2.
To obtain better instructions.
Status report.
Status report ছিল দেখি Which matter are you looking at? Akram Hossain.
Yes, ma'am.
আরে তুমি তো আমাদের রুবেল মন্ডল দিচ্ছ
31.
Yes, but we want the status report to come on record.
Highly,
because then we will
I understand.
Reject on merits.
Well, the status report they cannot examine. That instructions we have from our side, that it's going on a very turtle speed.
Since there is a direction, file it.
I'm going to copy that.
You have prepared it, you know. You are so confident on my report.
I have
That
prepared.
is why I am shocked.
I have prepared.
Yes, yes. The clients are quite influential, seems like. Because I have never seen a status report to be prepared like this by an investigating agency. I'm sorry to say, Madam.
Hmm. It doesn't say how many you intend to examine.
All are police persons.
No independent
There are
witness.
99 kilos of ganja.
Yes, but no independent witnesses,
Qualified
all are
witness.
police
No,
persons.
independent witnesses are there too only.
Very crazy. Issue. Status report filed by the state in terms of our order dated January 7, 2025, be kept with the records. Paragraph 99 kilograms of ganja was recovered from joint possession,
No, from him.
from the exclusive possession of the petitioner.
No, it was joint possession.
No, no. Joint possession. You are the driver of the vehicle.
Charge has been framed against two.
Joint possession.
From the joint possession of the accused persons, including this petitioner, of two accused persons, Karu, including this petitioner. Stop. The petitioner was arrested on October,
3923.
on September 30, 2023. Stop. Charge has been framed and witness action has begun. Stop. We cannot say that there is inordinate delay in progress of the trial. Stop. There are 10 charge sheet named witnesses. Stop. Paragraph in view of the restrictions in section 37 of the NDPS Act, we are
But
not
will kindly
inclined.
record, my lord, on last 9 months, only one witness has been examined in part. Lordship will kindly record that.
We are not inclined to entertain the petitioner's prayer for bail, at this stage. Dismiss করে দাও। আগে ওই যেখানে একটা এটা বলার আগে আমাদের প্যারাগ্রাফ করে দাও। Learned state advocate points out, learned advocate for the petitioner points out that during the last 9 months, only one witness has been examined, and that too in part. Examined, and that too, in part. For dismiss করার পর, you want expedition? No.
Yes, yes. My lord, he wants.
Oh, my lord, everything he wants, my lord.
Keeping in mind the period of detention of the petitioner, we request the learned trial court to take all steps for expediting the trial and concluding the same on an early date.
Limited to communicate.
Paragraph the parties to communicate this order to learned trial court.
Great.
I am for the petitioner. This petition is custody. I am going for not today.
Not today.
I have been requested by Mr.
I'm for the petitioner, but no seizure from this petitioner. His implication is from the statement of co-accused. 130 days in custody, my lord. Charge sheet submitted.
Yes, madam.
Next date is fixed for
Arre Baba, next date.
Next date.
What he says is correct.
আমি যা বললাম সেটা
No, no, yes. No, well, can you see, man?
ও অ্যাকচুয়ালি স্টেটমেন্ট সেটা জিজ্ঞেস করি
Yes. Anticipatory bail has been rejected by this honorable court, my lord.
Yes.
You are here to assist us.
Was there any recovery from him?
Caesar list,
Start
my lord.
reading. Now start reading your brief.
Excellent.
মাইলট স্পেসিফিক প্রশ্ন করছে এটা সিজার ওই যে এটা কে এসছে ও
অমল বড়
অমল
সিজারটা হচ্ছে
What is?
অনন্ত
Is Amol Borgan.
from অনন্ত সিজার
Nothing has been seized from Amol Borgon.
No, no. সেটা কিছু পাইনি।
দেখেছো তো
হ্যাঁ, এটা season list টা পাইনি। Yes, কালকে see.
What?
The season list. Oh,
So there, anything has been recorded from
no,
it?
my lord, no. But
that is
evidence
the
date has been fixed, my lord.
Only one question and you have taken 5 minutes.
No, my lord, because it is not, my lord.
And he was implicated on the basis of statement of co-accused.
Yes.
Any money trail, any CDR,
Yes, CDR, my lord, page
CDR implicating him.
89 to 10.
Whether
এবারে
টাইম নাও
মুশকিল।
পড়ে নাও টাইম নাও টাইম এখান থেকে
this type of assistance, we are not
But
giving
his
it.
anticipatory bail prayer was rejected by this court.
That we find from here.
এক সেকেন্ড
What is your name?
অমল বর
All Varun.
বর্মন
Alias Amul Bormon.
ইয়েস আমুল বর্মন
Butter.
বাটার
Alias Butter Bormon. কি হলো time?
let Mr. Shur come madam because his handwriting
Mr. Shuri is leading her.
yes madam because
Come back on the 21st, sir. If there is no CDR, no money trail, we may consider. But we have to be told that. Not today. এই ওই উপরের দিকে যেন থাকে এটা যেরকম আছে।
My lord, I am for the petitioner. My lord, in this case, my lord, brown sugar recovered from my brother's house, that is Samir Sheikh, my lord. Based on the statement of just because I am the brother of the principal accused, my lord, I have been implicated in this case. All of my brothers have been implicated in this case, my lord.
Family business.
No, my lord.
absolutely
No. Separate accommodation, my lord. In a same building, we are living, my lord. Living
Was
separate.
recovered.
but recovery is 7 kg 900 grams
My
of
lord,
brown sugar
Kindly seize the final report.
and 32 lakhs of cash
What is your business, sir?
and a money counting machine.
What is your business?
My business, I am a driver, my lord.
Driver.
Kalasi.
32 lakhs.
Not from me, my lord. From Samir Sheikh.
He
From his
resides in
bedroom.
the same house.
Separate accommodation, my lord. Separate
So,
living.
like my lord said, it's a family business.
No, my lord.
Brother, Sumit Singh is your brother.
He is my brother, my lord. But
What is
apart
his
from that,
business? What is his business?
his business, my lord, as much my knowledge is
He's
that
a-
my lord, he is also running his.
Caesar list is there.
Does it name Solomon?
My lord,
Suleiman?
Satabuddin is the owner of the house. Satabuddin is the father.
Father, my
Now,
father.
this father, having three sons residing in the same house. One is Soleiman Anam, one is Samir Sheikh, and another is Atilal Sheikh. Now, Atilal is absconding, Soleiman is before a lordship, and Samir is in judicial custody.
So two are judicial custody.
Samir and Suleiman in judicial and father also in custody.
No, father has not
no, no.
made accused, my lord.
Father not accused.
That
Father
man-
doesn't live in that house.
Same house. He's also living in the same house.
There, but he's
বারবার মরে গেছে।
if father is not accused,
No.
his house.
Father, I don't think is alive.
Huh?
He's alive.
Alive or not?
Yes, alive, my lord.
What is his age?
My lord, around more than 60.
More than 60. Maybe
My lord,
in his
my lord,
age, but his sons are carrying all these things.
my lord, kindly seize the FIR. Page 9.
Does the Caesar list name him?
No.
But Caesar list is from the house.
House of Samir Sheikh. Bedroom from the.
But he was
My lord,
present. He was
my lord,
present.
you can imagine what is the price of 7 kgs 900 grams of heroin. My lord.
No, can't imagine because I have no idea.
Brown sugar.
It's heroin.
Heroin.
It's brown colored powder. It's heroin. FSL is heroin.
And brown sugar is white.
How much will it be?
But it's around once I have asked, it's around 65 or to 1 crore depending on the quality.
Oh, there's good quality heroin, bad quality heroin. Wow.
So the good quality or bad quality?
I don't know, Malad. I have no personal knowledge about this. Malad, kindly see page 10.
Charge seated.
I have been charge seated.
How long are you in custody?
Well, 245 days.
Nothing.
Not on the ground. Malad, kindly seize the page 10. FIR, my lord. This is personally Malad, recovered from the bedroom of Samir Sheikh, my lord. Apart from that, Malad, is there any money trail that no criminal antecedent, Malad, nothing.
Him to whether there is how you are
My lord, what is the requirement at this stage? My lord, I reside in a house with my learned brothers. From my house, from that house itself, and this quantity of heroin and this quantity of cash and a cash counting machine is being recovered, and I will say I don't know anything. I reside in the same house, my lord.
So then everybody will be the accused, even the female members.
Right.
I want to know from you. Please clarify.
161.
Yeah, the cash is not lying on the floor. Cash is kept in Almira. Whose Almari it was? Please answer.
Yeah, yes, it was. Atilal.
Atilal's Almira under lock and key.
Nothing, no lock and key is required.
Whatever. Then to consider. Okay, this is 245 days. Charge sheet submitted. There is no delay, and we have to record that you are not guilty. Prima facie. That is a problem for me.
But prima facie, my lord, Mayor, I'm a brother. What is
Proclamation
the
attachment
incriminating?
process.
My lord, what is
at the
incriminating?
absconding accused.
May
is
I
going on.
reply, my lord?
He was present in the.
But he's as per the statement, he was there. He left.
So you allowed
Degree of complicity will come out in the evidence.
My lord, but my lord, prima facie, what is the incriminating material against me? That has to be, my lord. My lord, just because I'm a brother, my lord, in a building, my lord, in an apartment, my lord, there may be so many families.
So many. It's your family only residing that
My lord,
place.
it is house, but separate. We are, our kitchens are separate, my lord.
That is factual matters that will be decided.
My lord, then just because I'm then my father has been left, my mother has been left, my lord. Then all are the accused persons.
Landed counsel for the petitioner says that the petitioner is in custody for about 245 days. Nothing has been recovered from him. The house belongs to his father. Stop. As he is only a resident of that building, cannot be a ground for his arrest and detention. Stop. He is a truck driver by profession, and as such, considering his period of detention and materials on record, he may be enlarged on bail on any condition. Stop. The landed counsel for the state opposes the prayer for bail. According to him, from the concerned premises, how much?
7 kg 900 grams of heroin and 32 lakhs of Indian currency of heroin.
Not heroin.
And
32 lakhs.
And 32 lakhs 55,000 of Indian currency note.
Indian currency.
And one counting machine.
And one money counting machine have been recovered from the said house. Stop. The investigation is complete and there are sufficient incriminating materials against the present petitioner along with other accused persons who are relatives of the petitioner, showing that they are running the racket jointly. Stop. If the petitioner is enlarged on bail, the prosecution may suffer. Stop. We have considered the materials on record and we find that there are sufficient incriminating materials against the petitioner. In view of the restriction of section 37 and also considering the materials on record, we are not inclined to allow the prayer for bail of the petitioner at this stage.
Let's see.
I'm for the petitioner, Lordship. Lordship, covered by Idul Mia's judgment, Lordship. Lordship, I am arrested on 22nd February 2024, Lordship, and charge sheet submitted without FSL report on 31st October 2023.
2023?
Yes, Lordship.
Arrested 24?
Yes, Lordship.
23 charge sheet submitted?
Yes, Lordship. And Lord, till NDPS case, Lordship. I mean,
So here, Bhajakuri Golpo.
Charge sheet 23 and arrested in 24.
yes, Lordship. Right. Subsequently, I have been arrested, Lordship. I have been arrested subsequently.
Then how
And
will come?
till date, Lordship,
How?
till date, FSL report has not been submitted, Lordship.
So you are absconded.
No, Lordship, I was not.
The accused are also absconding. He was absconding.
Nothing was found from me, Lordship, and
He was intercepted. He fled away.
nothing was found from Pia. How can I know, Lordship, that my and yes, Lordship. Yes, Lordship. There is a rejection, Lordship, that is annexed. First application. It is the first. It is the first application, Lordship.
Not press করবে না
withdraw করবে না my lord?
Because it is not a case of Idul Mia.
Lordship.
And you were absconding.
But Lordship, no recovery case. Okay, Lordship, I am withdrawing then.
My lord, records, my lord, my problem we are facing, my lord, because once it is not pressed, then there will be a forum shopping. So my lord makes little observation regarding our submission.
Lordship, withdrawing my application.
Yes, you can withdraw.
After making argument for some time, the right is that withdraw the application, paragraph, or at least the right.
Yes. Talk about and this is in the Patata one.
Item 1127.
127.
1000.
100. Oh,
My lord, Mr. Shomaji Dashmapatra is appearing before the courtroom number 28. My lord, he is on his way. My lord, let them start.
এই ডেট গুলো ঠিক আছে কিনা দেখতো বলে দিচ্ছি
The sending of directly sending the charge sheet. FSL report. Yes.
I had told your lordships, I had placed the judgment of Justice Sanjay Dutt that once the FSL report or the Sanjay Dutt doesn't say FSL report. Once the charge sheet reaches the court, and in the meantime, the accused has not exercised his right to get him released on bail, that right goes. He has the right. He has to exercise it. If he fails to exercise his right, and in the meantime, charge sheet is filed, then
Mr. Roy, that is the moot point. When can you say that charge sheet is filed?
One by one.
Yes.
This is Sanjay Dutt. My lord, there cannot be subject to correction by your lordships. This is a 5-judge bench judgment. There cannot be any interpretation of judgment. There can be interpretation of statute. But whatever it is, my lord, the Supreme Court has gone to the extent, I don't mind the Supreme Court going because I am here for small time, maximum time I was there, being liberal, that even an oral prayer of the accused or his advocate during the course of the hearing of a regular bail application, this point can be considered by the court. I'm not challenging that also. My lord, I was addressing your lordships. My lord, what happens? A cognizable offense is committed by somebody, the police comes to know about it, registers a case. Then police tries to find out who are the offenders or what are the evidences against the offenders. Police is nobody to convict him. The punishment to keep an orderly society, it is your lordship's court which sends him to the correctional home or to the gallows or whatever it is. It is your lordships which maintains an orderly civic society so that the general people are at peace. They can sleep at home. How your lordships exercise, I'm addressing your lordships will include that. I'm talking about the court of the learned magistrate also. Learned magistrate gets what? From the police? In the charge sheet? Name of certain persons? Police claims these are the persons who are involved in commission of the offense. None of the opinion of the police, whether he is filing a charge sheet or is filing an effort, is binding on the court. The court will peruse its material, court will take its own course. Court might direct further investigation, court might direct discharge, court might call for other persons. Now, in the case of Dharamveer Singh, the Supreme Court has gone up to the extent that at the time of taking cognizance of the offense also, 319 can be invoked. Fresh witness accused can be called in. If the learned magistrate sees that the police intentionally did not name Devashish Rai, he is squarely involved in the commission of the offense. Learned magistrate can do it. Now, how the learned magistrate assumes jurisdiction? If your lordship kindly takes up the compilation given by my learned friend, I will not. I will. Oh, ওটা শুধু আমাকেই দিয়েছিস?
না, হ্যাঁ, ইয়েকে দিয়েছি, কৌশিকদাকে দিয়েছি। আচ্ছা,
ও আমাকে দিয়ে ওই একই।
না, আপনি আমার পেছনে লাগতে বলুন।
তোর পেছনে কেন লাগতে যাবো ভাই? তুই আমার কি ক্ষতি করেছিস বা আমি তোর কি উপকার করেছি? বিদ্যাসাগর said that আমি তো ওনার কোনো উপকার করিনি, উনি আমার অপকার করছেন কেন? My lord, cognizance is not a defined word. My lord, he has referred to this.
Who are?
No.
Constituted to.
My lord, will kindly come to page 6. Section 190 of the code. Has my lord got it? My lord, I am placing it. My lord has read it many a times, but I am placing it. Subject to provisions of the chapter in magistrate of the first class and in magistrate of the second class, this will be the special court also. Specially empowered in this behalf under subsection 2 may take cognizance of any offence upon receiving a complaint of facts which constitute such offence, upon a police report of such facts, upon information received from any person other than a police officer or upon his own knowledge that such offence has been committed. What is the problem in the FSL report travelling directly to the court of the learned magistrate? My lord is saying then what is the necessity of filing a supplementary charge sheet? My lord, Justice Sinara will be knowing better. Both, my lord, my trial court experience is 0. FSL report, ballistic experts report,
I had put a question, what prejudice is caused to you?
No,
That she will answer.
my lord, I am admitting a defective charge sheet is filed without the FSL report as per your lordship's judgment in Idul Mia. Fine. Now, when this C comes into play, the defect is cured. When the learned magistrate exercised his, I will say the special court, exercised his jurisdiction under C by receiving the FSL report and giving a signature on it, my lord, he puts an initial. That means he has perused it, he has applied his mind and has directed this be kept with the record. Till that date, I had shown to your lordships on the last occasion that the notice upon the office of the public prosecutor was served on the date when the supplementary charge sheet had been filed in the court below. He had not exercised his right before that. It is only after 30th of March 20 or whatever is the date when I was served upon the application. During the course of, my lord, your lordship will kindly, my lord, I'll take the words of Mr. Sudipto Moitro. It has a checkered career. First argument was section 50.
না না স্যার এই মামলাটা সেটা না এই মামলাটা সেটা না এই মামলাটা সেটা না সেটা সেটা অন্য মামলাতে সেটা অন্য মামলাতে না সেটা এটা না সেটা এখনো ডিসপোজ অফ হয়নি
Then non-compliance of 207. Now this 167.2. Anyway, this oral prayer for discharge under 167.2 could not have been made prior to filing of the supplementary charge sheet, because it is the date on which I had been served with the notice. Obviously, on the following day, I am saying on the following day, your lordship heard this matter. And during the course of the hearing, he had raised this point. Kindly raise me on default bail. He has
So therefore, Mr. Roy, are you saying that he exercised his right to obtain statutory bail only when he served notice on your office?
He had not exercised his right to be released on statutory bail at any point of time. He exercised his right to be released on statutory bail during the course of hearing of a regular bail application before your lordship.
Filing of a bail application is not exercising the right?
No, statutory bail and a regular bail are not the same thing. Statutory bail, he is asking for being released on merits. And statutory bail, he is saying, I have, my lord, supposing, my lord will kindly take an example. A person is picked up by the police. He is not produced in the court for days together. My lord, after 24 hours, the detention is illegal. He has submitted the judgments, your lordship will find.
I'm not on that. I'm not on that. I am on at what point of time you can say that now he has exercised his right. পাবে কি পাবে না সেটা অন্য। এটাই তো বলছি, তবে ওর মতে যখন Yes, Mr.
He has relied upon certain judgments of the Supreme Court. Your lordship will find from those judgments.
I have seen that 3/10/2024, he gave you notice. So on that day, he exercising what is your submission?
He has filed a regular bail application. My lord, regular bail application and an application for being discharged on bail, or saying that I am ready and willing to furnish bail bond are two different aspects. The judgments he has cited upon, your lordship will find those are not same applications. Regular bail application being released on bail and an application for being released on statutory bail cannot be the same thing. Just because he has filed an application for bail does not mean he has exercised his right to be released on statutory bail. He exercised his right to be released on bail. He has cited a judgment. During the course of the hearing before your lordships orally, the Supreme Court says, yes, the High Court ought to have considered that oral prayer also. But when this oral prayer was made, that will be the date. In any event, this oral prayer could not have been made before your lordships before the 3rd, when I was notified. Your lordship was not hearing an ex parte bail application. We do not know the dates. We don't want to go to the dates. So the application was heard on 4th, I am saying. Your lordship heard the application on 4th. So he is exercising his right on 4th. But on 3rd, the supplementary charge sheet has already been filed. Even if your lordship...
Mr. Roy, just for understanding again, if this application, which does not say that the prayer is for statutory bail, if this application clearly had it stated that your petitioner is exercising the right to obtain statutory bail because of reasons A, B, C, then would the filing of this application amount to exercising the right? If I am offering bail, I am claiming statutory bail.
Yes. My lord, his judgment is like that. The judgments of the Supreme Court is like that. Once he files the application, his job is done.
Correct.
My lord, the prosecutor or the court, I am not saying the court is biased to an accused. The prosecutor might say, my lord, I will have to take instruction, my lord. I'll produce the charge sheet. I'll call for the case diary. Kindly keep it tomorrow. Then on the next date, in the early morning, the charge sheet is filed. Then the argument is made, my lord, charge sheet has been filed. 167(2) is not maintainable. This has been deprecated by the Supreme Court. The Supreme Court says, once an application for statutory bail has been filed, it has to be entertained on that date itself. Even if it is not possible to entertain that application on that date, it is being entertained on a subsequent date, the court will go by the fact that as if that application is being entertained on that earlier date. His right cannot be defeated by filing a charge sheet.
In this case, the application was moved on 4th.
It was
after 3rd.
It was hard after. Definitely, this right was exercised definitely after 3rd.
And 3rd, the supplementary was filed.
3rd, the supplementary was filed. My lord, তোর application, তোরা তো আবার বড় হয়ে গেছিস।
না আছে আমার কাছে
আছে, হার্ড কপি আছে।
কেন থাকবেন? আমি বললাম আপনি আমাকে
বুড়ো রে ভাই, আমি
না সেটার জন্য
পারি না।
আপনি আমার পেছনে লাগবেন আমি জানি।
আমি তো পেছনে লাগছি না রে বাবা, তোমাকে কম মামলা দিয়েছিস, তোর পেছনে লাগতে যাব। আবার কালকে যদি গভর্নর ডিসপ্লিজড হয়ে যায় আবার দিবি।
I was appearing with Mr. Roy in a death reference case. Marvelous experience that was. Marvelous
Which case?
In a death reference case.
Death reference.
It was a marvelous experience for me.
For the convict?
No, acquittal.
No. He's saying convict.
Oh,
yes. My lord, will kindly come to his application at page 4, paragraph 7. My lord will read it along with paragraph 6, 8, 4. Page 4, paragraph 7.
Yes.
But my lord will read it along with paragraph 6, 8, 9, 10. It is not an application for being released on statutory bail. More so paragraph 10. This is not, he's saying, my lord, I don't need your blessings. I need your order. I don't need your blessings. I need your order. I have earned that order. Now your lordship has to pass that order. This is not that application. Your lordship will find in the judgments relied upon him. The two applications are of two different nature. Just by filing a regular bail application, you cannot claim to have exercised your rights under section 167(2). My lord, I don't remember.
He could have asked the court why in the course of argument to consider this as statutory, but that
he had.
But that was after charge sheet.
After charge.
Supplementary charge sheet.
In fact, the Supreme Court has said, if during the course of the hearing, regular bail hearing, orally this prayer is made, the court should entertain that.
Whether accused is entitled to bail on that day, that is a factual aspect.
Merits.
No, if the learned counsel commits a mistake in stating whether his client will suffer.
Yes. Yes. My lord is suffering from broken leg. Your lordship travels to an quack, and the quack amputates your lordship's leg. It's your lordship's fault. My lord will not take me. I am saying like that. I should have said the example should have been on myself. Choice of advocate is on the litigant. My lord, if your lordship wants, I can produce that judgments also. The commitment of an advocate before the court is binding on his client. My lord, it is unfortunate that
on facts.
it is unfortunate that we call ourselves as learned brothers, and we are the only profession who are pardoned in spite of making faults. My lord, will kindly allow me to amend the constitution. My lord, kindly allow me to amend the prayer portion. My lord, this case number has not been gone. My lord, just things. A doctor in a nursing home is saying that, oh, Mr. Rai, kindly forget. I have left the scissor in your wife's abdomen while doing this surgery. My lord, kindly amend, kindly. The lordship just thinks it, and we call ourselves, pat ourselves as learned brother, judge, my learned brother. We don't know how much learned we are. I can waste your lordship's time.
We are মোটামুটি বুঝে গেছি.
Page 58, your lordships will take paragraph 40. His prayer that the oral can be made. I am saying whatever is in his support, oral prayer can be made, it can be entertained. It should be entertained. I am just, my lord, I cannot remember so much. My lord, this notice upon the public prosecutor and its impact, your lordship will get at page 106 of his compilation.
Page
58.
Page
Initially you told
58, paragraph 40 of the compilation. Page 58, paragraph 40 of the compilation. That an oral prayer ought to be considered even in a regular bail application. Now your lordship will see this default bail will be considered only after serving me a notice. That your lordship will get at page 106, paragraph 111 or it is 111th or Roman 3. That not Baba. Hey, Roman 3.
Sanjay Dutt.
Rest is immaterial on this subject because it is what I have said, Your Lordship. It's an indefensible right. Charge sheet not filed. I have come to Your Lordship's court. Your Lordship has to pass the order. Your Lordship cannot supposing there is a full court. Your Lordship rises for the day. Behind his back, behind Your Lordship's back, tomorrow 10:30, I get the charge sheet filed. Your Lordship is taking up the matter at 2 p.m. I say charge sheet has already been filed. So default bail is not. Your Lordship will be considering the application tomorrow as if Your Lordship is hearing it today. That is the judgment of the Supreme Court. This right cannot be taken away by protracting the hearing of the 167.
These points actually pale into insignificance if we accept your submission that the magistrate is empowered by law to receive the FSL
My
report
respectful submission.
directly. There is nothing in law which says that he cannot.
My Lord will kindly pardon me. My Lord will kindly pardon me. This country doesn't have that much of infrastructure to have the FSL report which the US government can have. My Lord, if something happens in Punjab today, what I am told is the police is not allowed to enter the crime scene. Pehle FSL bulao. And they have mobile petrol vans. I had thought of going, but Chandigarh FSL is it is almost as same as American standards.
Would you require some more time?
No.
He may want to respond to your argument or not necessary.
No. I'll do because
you will.
he has raised. Yes.
How much time? 15 minutes?
Around 15 minutes.
Huh?
Around 15 minutes.
একদিন একটার সময় দিয়ে দাও ওকে একটার সময় টাইম দিয়ে দাও সোমবার হ্যাঁ Monday 1 p.m.
Monday 1 p.m. perhaps one of my matter is fixed if I'm not wrong. Probably fixed আছে দেখো
21st.
I don't have any issue.
না Monday the 20th দেখো বলছে ফিক্সড আছে
Probably আমার
20 তারিখ
সেটা তো বোধহয় আপনি আছেন ওই ডিসমিস ফর ডিফল্ট 21 তারিখে সোমবার 4টে ডিসমিস ফর ডিফল্ট তাহলে হ্যাঁ ঠিক আছে নো প্রবলেম
Mr. Roy, learned public prosecutor, concludes his argument. Paragraph lists the matter once again on January 20, 2025, marked 1 p.m. for learned advocate for the petitioner to make his submission in reply.
There is another matter. My Lord, we have 1 day left, 1 minute left. My Lord, the next matter, he wants to use a written, he doesn't want to waste your lordship's time. He wants to use a written point. Same point. He will use a written notes of argument.
The list.
Yes, next matter.
Your lordship last occasion tag both the matter.
Oh, it didn't tag, but it said
one after
one after the other.
Oh, I see. Shonjit Mondol.
He wants to use a written notes of argument. He will sub me a copy. I'll give a reply. Your lordship will pass orders. No hearing.
When will you file the written note?
I will hand it over to my learned senior within 7 days.
তাহলে we'll not keep it on Monday. We'll keep it
No, Your Lordship keeps it on as to be mentioned after a fortnight. We'll file CAV.
No, filing, no, we have to hear him.
Your Lordship hears him. That's not an issue.
Otherwise, may I propose one thing subject to
next
Lordship's
matter.
confirmation? If I do this today at 2 to 2:15, 2 to 2:15.
না আমি তা বলছি না এর ম্যাটারটাই আমরা জাস্ট উইল ফাইল রিটেন নোটস অফ আর্গুমেন্ট ইওর লর্ডশিপ will not address your lordship.
We should take up these two matters together because we'll decide them together, right? So if you give Mr. Roy a copy of your written note by next Thursday, as you said, 7 days, then after that we'll keep a date for Mr. Roy to respond to your written note.
I will also file a written.
You will also file a written note.
Yes, that is why I was saying your lordship keeps it on to be mentioned any
এটা
day.
করো তাহলে
Detag it from it.
1 p.m. Monday you finish off it.
Yes.
ঠিক আছে, এটা হয়ে গেল অর্ডার। নেক্সট ম্যাটারটা অর্ডার করো। Let this matter be listed under the heading to be mentioned. Next Thursday ডেটটা দিয়ে দাও।
No. Thursday week, the parties to file written notes of argument on
You
that date.
wanted 1 week?
I will serve in
Oh, I see.
I will also written. I will also
তাহলে Thursday week
will
ডেটটা
not waste your lordship's time in the court time.
হ্যাঁ 30 তারিখে under the heading to be mentioned. Stop learned advocates for the parties say that they will exchange notes of arguments in the meantime and file the same in court on the adjourned date.
Grateful.
3:30 কি করবে? 5 মিনিট লাগবে। দুটোর সময় 5 মিনিট তো লাগবে।
Item 36, I am for the petitioner. My lord, my case is squarely based on Idul Mia and Rakesh Shah. Most probably Rakesh Shah is the better soothing. My lord, I am submitting the judgment itself.
Need not submit, just
My lord knows, my lord.
give
My
us the
thing-
dates.
My lord, petitioners are arrested 31st January 2024.
Charge sheet.
My lord, charge is submitted 24/6/2024 without chemical report.
180 days.
My lord, 180 days in comes, my lord, after 6 days later, that is on, my lord, 36/6/2024. Approximately, my lord.
Application for statutory bail.
My lord, I must be candid, my lord. There is no statutory bail. So far, my subject to understanding. Petitioner files bail application 3rd of October 2024.
Trial court.
Trial court. It was rejected. My lord, chemical report submit very first time 13/9/2024, and it was immediate 9/2024, and it was immediately taken by the IO for filing of the supplementary charge sheet. Now, my lord, I filed this bail application before this court, challenging the order dated 3/10/2024.
When was supplementary charge sheet filed?
After filing of this bail application, 18/12/2024.
My lord, supplementary charge sheet file 25th September.
No, my lord.
2024.
This is the,
My lord, the case diary.
Yes, just show us.
my lord, I can show from the order sheet also.
Sir, order sheet is often wrong.
No, my lord, there is
See, charge
information.
sheet will show.
My lord, they will show when it has been submitted. There is a number that has been written.
হ্যাঁ, এই ফালতু। হ্যাঁ? কোথায় করেছে? ট্রায়াল কোর্টে, কোথায় statutory bail? 439 application ছিল। 437,
My lord, when it was filed in the court, my lord, it may be prepared on that date.
25/9.
Yes, my lord. And
But
This is
this is my lord.
what is the
My lord, I got information slip that it was filed in the court itself on 18/12. This is the information slip, my lord, from the court itself. 18/12 it was filed. And order sheet clearly shows till 18/11, thus there are no supplementary charge sheet. It is on record, my lord.
Sir, please find out.
instruction is missing.
Hey, Eshwar, Debojyoti. The
18 বার তো
petitioner seeks ওগুলো সব এক্ষুনি তোমায় আচ্ছা ঠিক আছে ডেটগুলো দিয়ে দিও যেরকম দেবার হ্যাঁ ওইটাই তো ডিসপিউট ওই ডেটগুলো একবার করে দেখো arrested 31st January 31 charge sheet filed without FSL June 24 180 days expired June 30
No, third of January.
bail application before trial court October 3
Submit করেছে 30.
না 13 is the 13 September is the date of FSL.
Yes, 13 September is when that FSL has been filed before the court. Subsequently, IO took back that copy of the FSL
Oh,
report.
FSL was filed before the trial court.
Filed before the trial court. And it has been kept. Mala order, kindly see the order sheet.
When was it filed before the trial?
13/9/2024.
September 13 lekho. FSL report.
39 Mala.
30 or
13 September. Mala.
As per record, my lord, 12/9/24.
39 FSL report filed before the trial court.
Brother,
Then
what are
the investigating officer took it back for filing it along with supplementary charge sheet. Next, there is a dispute as regards when the supplementary charge sheet was filed. Stop. learned advocate for the petitioner says that the same was filed on
18/12, my lord.
December 18, 2024. Stop. Learned state advocate says that he needs to obtain instruction on that score. Paragraph lists the matter on Monday, 21st.
My lord.
So
My lord, subject to correction, the petitioner was arrested 3rd of January.
আমি কি বলেছি 31
31st maybe, my lord.
ওটা January 3 31
it's showing 1812.
Yes, my lord.
You do not know this information slip.
My lord, I must be candid, my lord. I tried to collect the certificate copy of the order dated, my lord.
গত 13/12/24 তারিখে সিভিল রিপোর্ট সহ জমা করিয়ে ফেলেছি। This is the plan.
13
My lord, this is
yes. এটা 1812 এ এই প্রিপারেশনটা হচ্ছে সিরিয়াল নাম্বারটা 13 তারিখে ও বলেছে আর কি।
My lord, I will come back with the order sheet, my lord.
Yes, come back with
I will come back with the order sheet, my lord. It will be better, my lord.
4th December. ঠিক আছে
18 is the date. I've been instructed, so I will come back with the order of the 18.
রাখো নেক্সট এটা
My lord, Monday, my lord. My lord. 21st. 21st. Grateful.
My lord, I am for the petitioner, lordship. Lordship, Idul Mia's case, lordship. Similarly, lordship, the petitioner is arrested on 17th October 2023, lordship. Lordship, charge sheet without FSL report has been submitted on 16/4/2024, lordship. 16/4/2024. Lordship, 180 days from the date of arrest completed on 14/4/2024.
14/4
4/2024. Lordship, the last rejection.
charge sheet was filed after 180 days.
Yes, yes, lordship, after 180 days.
82 days, 182.
Yes.
Lordship, I have the last rejection before the learned court below on 12/11/2024.
You applied for statutory bail.
Yes, lordship.
FSL is still not on record.
No. On 11th, he has filed on 12th. 11th, the FSL, the first order of losses is 11th, already court taken cognizance that yes, FSL received. On the next day, 12th, the file supplementary was filed on 13th. The three orders stand in the same page.
13/11/2024 supplementary with FSL report.
So 1 day before his statutory prayer, FSL was there before the court.
This is the point we are deciding now.
Yes, ma'am. That's
Mr. Roy's court পেয়েছে
directly receive করেছি।
Yes. And court
received a letter
asked
from
the order.
SI with a sealed envelope. On permission of learned PO, envelope is opened. Reports from FSL is received. Seen the report, taken on.
So, court taking cognizance and then the statutory prayer, it's
correct.
Otherwise, your lordship has to take the decision.
Exactly the point we are.
Absolutely. That's why, I did not.
So, we will keep it. এই ওটা কবে রেখেছি আমরা 2 সপ্তাহ বাদে রাখলাম ওই যে পিপি যেটা আর্গু করছিলেন 30 তারিখে 30th ওইটার সঙ্গে এটা রাখবে হ্যাঁ the point involved in this matter, i.e., whether the learned trial court could directly receive the FSL report from the laboratory without a supporting supplementary charge sheet, is being considered in 2 other matters which we have posted for hearing on January 30. Stop. Let these
Monday.
Lordship posted my matter on January 13.
Sorry,
And
we have posted one of those matters. Karan. On January 30, let this come with that matter. Let this matter be. সেটা নাম্বারটা দিয়ে দাও। 30 জানুয়ারি যেটা আসবে তার সঙ্গে এটা আসবে। শোনো 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 এটা একটু একটা ছোট অর্ডার করে নাও। অর্ডার ম্যাডাম উইল জাস্ট রেকর্ড এ শর্ট অর্ডার। বলেছি বলেছি না না তার আগে কিছু তো বলিনি আমি। এই যে এত ডেট ফেট দিল আমাকে, তার আগে ডেট ফেট গুলো বলেছি কি না? লেখো, the petitioner was arrested on October 17, 2023. Stop. Charge sheet without the FSL report was filed on April 16, 2024. Stop. না তার আগে করো 180 days expired টা আগে হয়েছে।
On 14.
180 days expired on April 14. তারপরে চার্জশিট ফাইলড অন April 16. ঠিক আছে, দরকার নেই। On November 12, 2024, the petitioner's prayer for statutory bail before the learned trial court was rejected. So in the meantime, on November 11, 2024, the learned trial court took on record the FSL report, which was sent to it from the concerned police officer.
Concerned department. Concerned department, the CFSL directly comes to
Concerned department. Stop. On November 13, therefore supplementary charge sheet was
filed. After receiving by the court, then we can pray, my lord, the investigating officer. Then only it will be supplied. Court takes the cognizance, my lord, CFSL on the record. Then only it can be supplied.
On November 13, supplementary charge sheet was filed.
Yes.
বলে তারপরে আমি যেটা বলেছি তোমাকে অ্যাড করে দাও, এটা ফিরে দাও। না
deeply honest.
In this matter, your lordship has been pleased to grant bail to two other co-accused, considering Idul Mia. Petitioner is standing on the same footing.
Lord, CFSL not yet filed.
Therefore, same footing. Then let us make it short, parity.
And in that case, because it was interim, now subject to correction, it will be confirmed.
Not only two conditions, my lord, he shall remain within Bahrampur PS and shall meet the officer.
এই কন্ডিশনটা লেখো অভিজিৎ আগে।
He shall meet the officer in charge Bahrampur PS once in a week and he shall remain within the jurisdiction.
Remain within Bahrampur police station jurisdiction or meet once a week. Officer in charge of Bahrampur.
Well, then once in a fortnight.
Once in a fortnight. The petitioner claims parity, citing an order dated January 7, 2025, passed in CRM NDPS 1862 of 2024, whereby two co-accused persons were granted bail by this bench. Stop. The petitioner says that he stands on the same footing as those two persons. Paragraph, learned state advocate, while opposing the prayer for bail, in his usual fairness, does not dispute that the petitioner herein is similarly circumstanced as the aforesaid two persons who were granted bail by this court. Paragraph, hence, on the ground of parity, we allow the petitioner's prayer for bail. Paragraph, accordingly.
Grateful.
I'm for the petitioner, my lord, led by Mr. Naunil De.
Led by?
Intermediate quantity of 4 kgs and 38 grams of ganja was recovered from the check-in luggage in the airport. I'm in custody for 112 days.
Complaint has been filed.
Submitted.
Yes.
Yes, my lord.
First appeal.
Second.
Second appeal.
Your junior.
What happened in the first ever rejected?
Allowed.
Hello?
Yes, my lord.
So then we must balance it out. Yes.
My lord,
Intermediate 4 kg.
intermediate quantity, my lord, charge sheet submitted, my lord,
Sole
with
accused.
respect in this matter, my lord, because
Hmm?
in this matter, my lord,
Sole accused in this
my lord,
matter.
my lord, in only relevant point would be, my lord, the paragraph 12 of the complaint, my lord, that from her statement, on that part, the investigation is still on. So we might require to file a supplementary charge sheet. my lord.
Investigation is on.
No, on that aspect, my lord kindly considers paragraph 12 of the complaint.
Page 10.
Page 10.
They will file supplementary if she'll cooperate with your further investigation, if any.
My lord.
It says so.
My lord.
Hey, he or she. The petitioner says that she has been falsely implicated. Stop. In any event, comma, intermediate quantity of ganja, i.e., approximately 4 kgs, was allegedly recovered from her luggage at the Calcutta airport.
My lord.
Yes, my lord.
Stop. She is in custody for 112 days. Stop. Investigation is complete. Stop. Charge sheet has been filed. Stop. Her further custodial detention is unnecessary. Paragraph. While opposing the prayer for bail, comma, learned state advocate says that on some aspects, investigation is still on and supplementary charge sheet may have to be filed. Paragraph.
A supplementary complaint will be, because since it is a complaint case, supplementary complaint
May have to be filed. Paragraph. On an overall assessment of the facts and circumstances of the case, and considering that investigation is complete and charge sheet has been filed, comma, we are inclined to allow the petitioner's prayer, also keeping in mind that intermediate quantity of contraband is involved, and therefore the restrictions in section 37 of the NDPS Act are not attracted. Accordingly, as a condition, arekta condition ঢুকিয়ে দিও, the petitioner shall cooperate with the investigating authority in case there is further investigation.
My lord, please grant the liberty to correct the cause title of the petition.
What is wrong in the cause title?
My lord, I had missed a slash between the sections.
Liberty is granted to learned advocate on record for the petitioner to correct the cause title of the bail petition. This is not right. 100% success rate is not right.
Sir, this is on the point of Idul Miya.
Abar Idul Miya. Still not filed.
Filed subsequently to the bail petition.
So, bail petition before the trial court.
Before the trial court.
Default bail.
Default bail.
Mentioned so.
No.
Yes.
So the mention করা আছে
order sheet mention করা আছে. Order sheet mention করা আছে, দেখো. Second paragraph, second line. And third
Statutory bail. Statutory bail. Yes, Ashok. The petitioner was arrested on
6th of March.
Stop. Charge sheet without chemical.
31st of August.
Without chemical report was filed. 31st August na kotho bollen? Stop. 180 days from the date of the petitioner's arrest expired on
6th of September 2024.
আমার মতন করে লিখবে কিন্তু September 6 or 6 লিখবে না। Stop. The petitioner applied for statutory bail before the learned trial court on
7th of November.
November 7. Stop. His prayer having been rejected, comma, he is before us by way of this application. Paragraph. Learned advocate for the state says that the chemical report along with supplementary charge sheet was filed.
FSL report was received on 3rd of January and the supplementary charge sheet was filed on 11th of January.
Says that the FSL report was received by the learned trial court on January 3, 2025. Stop. Supplementary charge sheet was filed on January 11, 2025. Paragraph. We therefore see that Initially, the charge sheet was filed without chemical report. Stop. As per our decision in the case of Idul Mia citation, the same was an incomplete charge sheet. Stop. Therefore, the petitioner became entitled to statutory bail upon expiry of 180 days from the date of his arrest. Stop. He exercised such right by filing an application before the learned trial court. Stop. Subsequent filing of chemical report cannot negate such right. Stop. Therefore, we are constrained to allow the petitioner's prayer for bail following our decision in Idul Mia, Supra. Accordingly.
Grateful, Lordship. Murshidabad, same district. Grateful, Lordship.
I for the petition.
Huh?
I pay for the petition. I'm in custody for 1 year, 23 days. I was arrested on 23rd of December 2023. Charge sheet was filed, Lord, on 16/6/2024. And my instruction is that on that date, Lord, the chemical report was not there. Lord, they have filed the, Lord, it's maybe, Lord, they have collected, but that has not gone, Lord. Your Lordship would kindly.
My lord, we have filed, my lord, on 23rd April 2024. Chemical exam that is there in the charge sheet, my lord.
Then
That's my instruction, Lord.
no, your instruction may not
That's
be
the
correct.
reason, Lord,
And my lord, charge framed, trial initiated, only 6
No, a
witnesses.
chemical report filed with the charge sheet.
My lord.
there are supplementary charge sheet, Lord, later on. The supplementary charge sheet is showing in a time election. And that is I'm not having. That's a supplementary charge sheet. Supplementary charge sheet, though. Lord, your Lord,
With the charge sheet, with the charge sheet. Complete charge.
That's a supplementary, Lord. That's why I'm saying. Lord, there is a supplementary charge sheet.
12/24.
12/12.
This is 35. Sorry. 16/6.
16 June.
16 June, Lord, is the first charge sheet. But there's a supplementary charge sheet also. That's what
That doesn't matter.
Oh, why you are saying that this is supplementary charge sheet?
So what you will proceed?
Lord, I'll leave it to Lord.
Huh?
I'll leave it to Lord.
No. Rejection. The petitioner says that he is in custody for 1 year and 21 days now.
Lord, yes. 23 days.
23 days. Stop. Beyond charge has been framed.
My lord, charge frame, trial initiated.
Witness, Lord.
How many?
PW1 is going on, my lord. Only 6 witnesses.
Stop. There is inadequate progress in the trial. Stop. The charge sheet was filed without chemical report. Stop. He prays for bail. Paragraph. Learned State Advocate shows us the charge sheet from the case diary. Stop. The chemical report was filed with the charge sheet. Stop. There was no defect in the charge sheet. Stop. Charge has been framed. Stop. Witness action has begun. So, paragraph. Commercial quantity of ganja? No.
Fentanyl.
27,000 bottles.
27,000?
From a truck, Lord.
Commercial quantity, bracketed like 27,000 bottles, bracket closed, of fentanyl syrup containing codeine phosphate. Being involved, we are not inclined to entertain the petitioner's prayer for bail, at this stage. Paragraph dismissed.
6 witnesses only.
My lord.
That is sufficient. You are 33, 44.
In charge sheet 13, Lord, they intended to rely on 6.
That's it, 33.
13. But they said that they are going to rely on
only 6.
6.
I can
But I bring for the petition, my lord.
My lord, I'm praying for not to do on behalf of Mr. Rana Mukherjee, my lord.
Let them
Not
to
today.
file the.
How long in custody?
Lord, 2 years, 5 months, my lord.
The petitioner complains of inordinate delay in progress of trial. Stop. He says that he is in custody for 2 years, 5 months. Stop. Only one witness has been examined. 1 out of?
12.
Only 1 out of 12 charge sheet named witnesses has been examined. Paragraph, let the state file a status report indicating the reason for delay in progress of trial. Stop. The report should also indicate how many witnesses the prosecution proposes to examine. Paragraph, এটা কি NDPS তো 21st পারবে না তাহলে 21st না হলে কবে হবে বাবা 28th list the matter 28th. You are appearing in the matter. Very well. File the report.
I am for the petitioner.
And I am for the state along with Mr.
Co-accused Mithun Mondol was granted bail by a coordinate bench of this court. I have annexed that order at page 10 of your lordship's brief.
Joint position.
No. Nothing has been seized from my possession. It was seized from the main accused Tinku Das. And my lord, I am being named as an accused on the basis of the statement made by the co-accused.
Mithun Mondol.
Mithun Mondol has been granted bail, co-accused, at page 10 of your lordship's brief by the coordinate bench.
He stands on the same footing.
Not subject to correction, I dispute such standing. It will matter. Not he is the principal kingpin from whose possession the Tinku Das, the 99 bottles of codeine phosphate was seized. My lord, there are series of CDR connections. One, he has 4 other antecedents of the same nature offense.
No conviction.
No. Sir, conviction. I am.
In one I have been acquitted, and one I have been.
And he was absconding for more than a year. After proclamation, and he could be arrested.
And no seizure from me, not in any case.
Certainly, I am not disputing that. I have never disputed such. But these incident will not otherwise, which did not forms the parity of Mithun. Mithun is a co-accused statement only. So far, his antecedent was not there. His CDR connections was not there.
CDR we call between whom?
From whom? From the house of the Tinku were seized. The petitioner's phone call. Along with that, 244 number of times it has been called to these persons. It is there. And 4 other incidents of same nature.
Tinku has been arrested.
Yes. From his possession it has been. And commercial point.
CDR with Tinku.
Why? Was it relative? Friend.
Co-villager.
How many? One or two calls may be there.
244 calls.
Don't know.
So,
and witness action, he could be arrested after proclamation and attachment.
Issue.
244 is the page. His connections with the calls from page number 82.
Oh, not 244?
No, 244 calls.
Sir, out of 19 charge sheet named witnesses,
19 witnesses, out of which
3 have been examined. And in the month of February, next
How
date.
long are you in custody?
100 days.
100 days?
within 100 days, 3 witnesses have been examined.
Absolutely. Yes. That's
price.
The petitioner says that he has no connection with the alleged contraband items. Stop. He has been implicated on the basis of statement made by co-accused person, which is inadmissible in law. Stop. He is in custody for 100 days. Stop. A co-accused person by the name of Mithun Mondol has been granted bail by a coordinate bench. Stop. Paragraph opposing the prayer for bail, learned state advocate draws our attention to the material in the case diary. Stop. Commercial quantity of fentanyl.
no, codeine phosphate.
Codeine phosphate. Commercial quantity of codeine phosphate was seized from the house of one Tinku. Stop. CDRs show
With the
numerous phone calls exchanged between this petitioner and Tinku at at or around the relevant point of time. Stop. Therefore, paragraph. Therefore, we find that this petitioner does not stand on the same footing as Mithun Mondol, who has been enlarged on bail. Stop. We further see that 3 witnesses have already been examined. Stop. Hence, it cannot also be said that there is any delay in progress of trial. Paragraph. Commercial quantity of contraband being involved, and their prima facie being incriminating, there being prima facie incriminating material against the petitioner, we are not inclined to allow his prayer for bail.
And this. Let
Dismissed. NDBS কমই হবে এবারে না, আমাদেরও একটা
Lordship, here also, Lordship. No. Yes.
It will be. Yes, the dates.
Lordship, arrest is on
Acha, dekho. The petitioner was arrested on
7th of May 2024.
Pecho. Stop. CS charge sheet without the FSL report was filed on
October 16, 2024.
Stop. 180 days from the date of the petitioner's arrest expired on
November 7, 2024.
Stop. The petitioner's prayer for default bail was rejected by the learned trial court on
November 28, 2024.
Pecho. Has been filed or not yet? When?
20th of December, my lord.
December.
On 13th of January, supplementary charge sheet filed.
Stop. Hence this application. Same paragraph. Hence this application. Paragraph. Learned state advocate says that chemical report along with supplementary charge sheet was filed on December 20,
The supplementary charge sheet filed on 13th of January and chemical report was received on 20th of December
received by whom?
by the police, my lord.
By the police. Learned state advocate says that chemical report was received by the investigating authority on
20th of December.
December 20, 2024. Stop. Supplementary charge sheet along with chemical report was filed before the learned trial court on January 13, 2025. Paragraph. We therefore see that the petitioner exercised his right to obtain statutory bail upon 180 days expiring, upon 180 days from the date of his arrest expiring, as chemical report was still not brought on record. Stop. Going by our decision in the case of Idul Mia, citation to the the petitioner is entitled to statutory bail. Stop. Subsequent filing of charge sheet of chemical report cannot adversely affect such right. Paragraph. Hence, we allow the petitioner's prayer for bail. Paragraph accordingly.
Great.
Lord, I am for the petitioner. My lord, my name was transferred by the other accused person of this case. I was not present at the place of occurrence when the raid was held. Nothing was recovered from me, and I am 84 days in custody now.
In which the charge sheet filed?
Investigation is.
Premature, we will not allow, we never allow. Investigation is continuing.
My lord, nothing was recovered for me.
Even
The
the
only basis is that my name was.
investigation is not complete, madam. Please understand. They still have 100 days to investigate.
Hmm.
What do you do? Yes. The petitioner says that there was no recovery from him. Stop. He has been implicated on the basis of statements made by co-accused persons. Stop. He is in custody for 84 days. Stop. He prays for bail. Paragraph. We see that how much, what is the,
57 bottles of.
we see that commercial quantity of fentanyl syrup containing codeine phosphate was seized in this case. Stop. Investigation is still on. Stop. Charge sheet is yet to be filed. Stop. We do not know, comma. Further investigation may reveal complicity of this petitioner in the alleged offense. Stop. Hence, comma, we are not inclined to allow the petitioner's prayer for bail, comma, at this stage.
Okay, ma'am.
Dismissed.
Obliged.
Can you see how confusing this order is?
চাকরিটা দিই বার করো চাকরিটা লাস্টের দিকে থাকে ডেটটা বার করো ডেটটা বার ডেট আই নিড দ্য ডেট Who is the date? আরে সিএফএসএল রিপোর্টটা কোথায় কত মাথায় আছে
দিয়ে দাও
246 আরে রাখো
46.
And I'm for the petitioner. Well, the petitioner is in custody for 26 months. And my lord, they took 1 year and 3 months to examine the first witness from the date of filing of the charge sheet, my lord. And my lord, charge sheeted witness is 8, and as per my instruction, till today, 3 witnesses have been examined. And another aspect is that, my lord, charge sheet was submitted on 16th of May 2023 without the CFSL report. And subsequently, supplementary charge sheet was submitted on 24th of July. But, my lord, I do not find whether any bail prayer was made in the meantime.
Then that won't help you.
Yes, my lord.
Milord, subject to correction, Milord, the CFSL report was made on 10th of May 2023. Charge sheet was submitted on the 16th of May 2023.
Along with CFSL report?
No, without the CFSL report. CFSL report was prepared, but the IO did not take the CFSL report into the record.
Anyway, it's irrelevant today because he did not apply for. Yes.
On the ground of the custody, my lord, 26 months.
Yes, Article 21.
Milord, three witnesses have been examined out of 8, Milord.
Yes, Mr. 2 year, 2 months in custody already.
Yes, Milord. That is true.
File a status report, as we always call for.
Yes.
The petitioner complains that he is in custody for about 2 year, 2 months. Correct?
Yes, madam.
Stop. Only 3 out of 8 charge sheet named witnesses have been examined. Stop. Charge sheet was filed
on the 16th of May 2023.
On May 16, 2023.
And the supplementary was submitted on the 24th of July 2020.
Not necessary. 16th of May 2023. Stop. After that, the prosecution took 1 year, 2 months.
3 months, madam.
3 months to examine the first witness. Stop. At the pace the trial is proceeding, it is anybody's guess when the trial will conclude. Stop. He prays for bail on the touchstone of Article 21 of the Constitution of India. Paragraph. Let the state file a status report indicating the stage of the trial and the reasons for delay in progress of trial, stop. The report shall also indicate inter alia, comma, how many more witnesses the state proposes to examine. Stop. Paragraph lists the matter. 21st.
21st কি বার? মঙ্গলবার 25
Yes.
শুনলে তো?
You were appearing in this matter.
Next one, Malad, next 47, Malad, I am for the petitioner. Malad, recovery from me is 6.2555 kilograms, intermediate quantity. Malad, still, Malad,
You have not mentioned the product.
Gaja, Malad, I beg apology, Malad.
6.2555 kilogram of heroin it could have been.
Malad, it's a medium quantity, but Malad, I'll be praying statutory bail because within 60 days it has to be submitted. In case of medium quantity, within 60 days it has to be submitted. Malad, paragraph 4 of my application. Malad, that has not been done. Malad, I filed bail on 5th November 2024. It got rejected. Malad, challenging that, Malad, I have come up before your lordship.
November.
Malad, custody since 30th August 2024.
Arrest is
38 2024.
Yes.
Malad, 60 days concluded on 29/10/2024.
Yes.
Malad, I filed this bail application on 5/11/2024.
Before
Got
the trial
rejected.
court, before the trial court.
Yes. Got rejected on the same day.
Saying that it's a application for default bail.
No, that I haven't said. Malad, charge sheet on 7/11/2024. Now I am in custody for 140 days.
And present application?
Malad, present application has been filed later on. Present application has been filed later on.
5th December.
So what is the punishment prescribed for intermediate?
But up to 10 years.
Up to 10.
Up to 10 years. So it's 60 days. Malad, your lordship knows.
This is the
New provision is VNSS.
Malad, DNSS 173.
170.
170.
173.
Or 67. 466. 187, Malad, I beg apology. 187.
You never asserted your right to obtain statutory bail. This was a 439 ordinary bail application.
Malad,
Order reflects that.
Yes, Malad. It was an ordinary bail. Malad, my point is that, Malad, upon expiry, it was incumbent duty of the court. That has not been done. Malad, I have filed a bail application that can be termed.
Yes, but then you have to make that prayer. You have to tell the court, treat this as my application for statutory bail.
Malad, subject to lordship's confirmation, Subhas Jadhav says so. Rakesh Pal says so.
What?
Malad, it is the incumbent duty. In fact, even if I don't do that thing, Malad, that has to be treated like statutory bail. Paragraph 41, your lordship would see, of Rakesh Pal. Malad, in that matter, I have submitted.
That matter can't be had
Malad,
now.
Malad, anyway, Malad, it's an intermediate quantity, Malad. Investigation is complete.
Charge sheet filed.
Charge sheet filed. Charge sheet filed.
Yes.
The FSL is dated 5/10/24. I have taken it out.
He is not on FSL.
Yes, Malad. I understand, Malad. That I
We'll grant him bail.
Malad, deep.
Hey.
Malad, my only submission
He is Allahabad.
Yes, Malad. He may elope to
Where is this
Prayagraj
case?
for
Where is this case pending?
Jhargram.
Jhargram.
Not leave the within the jurisdiction of trial court.
Because now if he goes to the Kumbh Mela, then it is.
Oh, then gone. go went gone.
Yes, my lord.
The petitioner says that he has been falsely implicated. Stop. Allegedly, what was
6.2555.
6.255 kgs of ganja was seized from him. Stop. He has no connection with such contraband item. Stop. In any event, comma, investigation is complete. Stop. Charge sheet has been filed. Stop. He prays for bail. Paragraph. Opposing the prayer for bail, comma, learned state advocate says that the petitioner is a permanent resident of Allahabad. Stop. If granted bail, comma, there is possibility of the petitioner absconding. Paragraph. Intermediate quantity of contraband being involved, comma, the restrictions in section 37 of the NDPS Act do not apply. Stop. Investigation is complete. Stop. On an overall assessment of the material on record, comma, we are of the view that further custodial detention of the petitioner is not necessary. For a condition usual kore debe, ota debe, to remain within the, not to go out of the jurisdiction of the learned trial court without the leave of learned trial court, to report to which police station?
Jhargram GRPS.
Jhargram police station.
Jhargram GRPS.
Jhargram GRPS. Once every week, madam? Once every week?
Yes, my lord. As your lordship's team.
Twice every week. Allahabad Baba. Twice every week. Until further orders.
Grateful.
Which may extend to 10 years. May extend to 10 years.
तो भूल बोल लो करेक्ट मैक्सिमम exactly.
And for the petitioner, lordship. Lordship, petitioners are in custody for more than 1 year, 11 months, lordship. A little above the commercial quantity, 28.200 kgs of ganja recovered from the petitioner.
Little over.
Little over. 20 kg is the...
You know that.
Yes, lordship. Lordship, nearly 2 years they are in custody, and charge sheet they were arrested.
2 years. Stage of trial, charge sheet to file definitely. Charge frame.
Charge sheet filed.
In commencement of the trial was because one accused person, namely Bikash Sardar, was absconding.
Lordship, total 6.
Now trial has commenced. As I find from my instruction sheet that 7th of October was fixed for cross-examination of PW 1 and 2.
So you file a status report. The petitioners.
There are 16 witnesses.
15 petitioners.
16 witnesses.
Now feel the pain of the big petitioner.
The
So this
petition.
is the legal service man.
The petitioners complain of inordinate delay in progress of the trial. Stop. They say that they are in custody for about 1 year, 11 months.
More than 1 year, 11 months.
For close to 2 years, Kurada. For close to 2 years. Stop. They pray for bail on the touchstone of Article 21 of the Constitution of India. Paragraph. Let the state file a status report indicating the stage of the trial. Stop. The report shall indicate the reasons for delay in progress of trial, as also the number of witnesses that the prosecution intends to examine. Paragraph 21st, Mr. Shengupta.
I'm praying only not to him.
Well, it's 49. Well, the investigation is going on.
What the statement?
So therefore, we will not allow it anyway. You know our view. It's going on. Come after charge sheet is filed.
In that case,
98 days.
to pass this order in respect of another query.
What? Allowing bail?
No, no. My lord, allow him to, I can't see the, my lord, allow to not raise this application as the investigation is not.
Then we can do the same here. এই এটা করে দাও এই order. Really a rejection.
It's only that our fees are going to be half fees.
Just because not pressed is used. Ridiculous. Oh,
Grateful, man.
try to find some other phrase.
Well, this is disposed of.
Yes, yes.
In this case also, I am relying upon your lordship's order of Idul Miya.
You are specializing in it.
No, no, lordship.
Yes. FSL file, not file.
Well, let
Not
me file
yet.
a report. Let me file a report.
You don't know
No, my lord, charge sheet filed within 180 days, but without FSL report. Whether
whether subsequently it has been.
subsequently it has been filed or
Come
not.
back on 21st then, Lekho. The petitioner relies on the decision in the case of Idul Miya citation diye debe. Stop. He says that charge sheet was filed without the FSL report. Stop. The same being an incomplete charge sheet, comma, he became entitled to statutory bail upon expiry of 180 days from the date of his arrest. Stop. You applied for default bail. The learned trial court having rejected his prayer for default bail, comma, he is before us. Paragraph learned state advocate seeks time to obtain instructions on whether the FSL report has been filed and if so, comma, when. Stop. Paragraph lists this matter once again, 21st.
Great.
Below commercial quantity ganja, 8 kg, 575 grams from a lady. She's a lady. 122 days she is in the custody. Investigation ended in charge sheet.
The charge sheet filed, my lord. And
Issue. Then the petitioner says that she has been falsely implicated. Stop. Allegedly
8.575.
no, 8.9965.
That is with the container.
How does it make a difference?
Minimum.
Approximately 8.9 kgs of ganja was allegedly seized from her. Stop. She is in custody for 122 days. Stop. Investigation is complete. Stop. Charge sheet has been filed. Stop. She prays for bail. Paragraph. Learned State Counsel, while opposing the prayer for bail, says that there is sufficient incriminating evidence against this petitioner. Stop. Paragraph. We see that the petitioner is a lady. Stop. Investigation is complete. Stop. Intermediate quantity of ganja being involved, comma, the restrictions in section 37 of the NDPS Act are not attracted. Paragraph on an overall consideration of the facts and circumstances of the case, we are inclined to allow the petitioner's prayer.
টাইম নেব তুমি টাইম নেবে তুমি নাও তাহলে আমার কেন আমি দোষ দিচ্ছ
2 weeks adjournment, man.
Why?
Weeks.
Last day, next day what evidence, man. Next day what evidence, man.
On the prayer made on behalf of the petitioner, comma, let this matter stand adjourned for 2 weeks.
My lord, may I submit one thing? My lord, same connected matter, item number 79, 77, Mr. Joydeep Bisha is appearing for the state. So, my lord, this matter also, they will take, my lord, 2 weeks adjournment.
77, you are appearing.
77.
You are appearing in 77.
Yes, my lord.
Same order kore dao 77 ta.
Because, my lord, there is a direction from the Honorable Apex.
One second, 77 time Mr. Joydeep Bisha for state. Etai uni hai.
Because in this matter, there is a direction from the Honorable Apex Court to conclude the trial within January.
Oh, let us see. 2 weeks. All right. 2 weeks মানে 2 weeks মানে কবে আসবে 30 3 weeks করো তাহলে
Let it be at the end of this month.
very well 30th January
Also place the order.
30th 30th ঠিক আছে চলো আমি দিয়ে দিচ্ছি আমি নাম দিচ্ছি না বুঝে শুনুন
I am for the Customs Authority, madam.
In item number 53, I've been informed that the petitioner who's appearing is ill and to ask for not today.
petitioner's advocate is ill
Yes, Your Lordship.
Mr. S.S. Banerjee
Shekhar Bormon is appearing in this.
not today will it help if we record an order no
I'm not pressing this application, madam.
কেন নট প্রেস করছো সেটা বলে দাও অ্যাকুইটাল হয়ে গেছে yes
Well, I'm not pressing this application, madam. Petition
Not
has been
pressing?
acquitted, madam.
not pressing
Yes.
you're a good man
Madam,
Hey.
petition has been acquitted, madam.
oh acquitted
Tendency of the bill application.
Well, they're not press. If the learned advocate for the petitioner says that the petitioner has been acquitted by the learned trial court, stop this. Likhecho. This application has become infructuous. Paragraph. The application CRM such and such is accordingly disposed of.
Yeah, 55 আছে।
Not today.
Not today.
Fifty-six, my lord, for the petitioner, my lord.
I'm for the
On
state, my
parity,
lord.
my lord. Kindly see the order, my lord.
Co-accused granted bail on merits or Article 20?
Delay, my lord.
Delay. As far as detention, period detention is concerned, same shooting. Issue. The petitioner claims parity, citing an order dated January 9, 2025, passed by a coordinate bench in CRM NDPS 1945 of 2024, whereby a co-accused person by the name of Ram Briksho Ram was granted bail on the ground of delay in trial. Stop. That person was in custody for 1 year, 4 months. Stop. The petitioner says that he stands on the same footing insofar as the period of detention is concerned. Paragraph, learned State Counsel, while opposing the prayer for bail, in his usual fairness does not dispute that the petitioner herein and the said Ram Briksho Ram are similarly circumstanced insofar as the period of detention and delay in trial are concerned. Stop. Paragraph, hence, on the ground of parity, we allow the petitioner's prayer for bail. Next, accordingly, same conditions.
Two petitioner is there, madam.
ওইখানে দুটো petitioner আছে তাহলে petitioners করবে আর এই condition গুলো দেবে আছে
চারজনের মধ্যে কাছে বেরিয়ে
start অব্দি দেখো না
Or I'm appearing for the STF.
Lordships, I beg to appear on behalf of the petitioner accused. Lordship, at first there are three things. One is this case may take a little time.
Why?
I think it has to be
No,
heard by
your
you.
thinking is all very good, but why? What was seized?
Gist is, Lordship, I've been accused. This case has been rejected once by your Lordships. But the fact was never revealed. Fact remains, there are 4 points.
What?
A huge quantity of NC3. Huge.
But
And not only
Lordship,
that, he is the manufacturer. He is not, the place from where it was seized, it was found that he was making a bottling plant.
It was rejected on August 30.
30th August 2024, your lordship has rejected.
Lordship,
Is there a change in circumstances?
several circumstantial changes are there. Lordship, number one, this is a case where I have been accused. I've been found as an accused. This is my third case. First case, actual, the thing behind the curtain is 10 lakhs rupees has been asked from me by the local Panchayat Pradhan. I have not given in his daughter's marriage. And the first case has been awarded where your lordship was pleased to allow me anticipatory bail. Now, once I went before the learned court below to surrender, I have been arrested from there. And I have been taken from Midnapur. The second case has been given where I have been allowed bail by the learned court below. No recovery has been made from my possession.
You have suffered a rejection on merits recently in August.
No, Lordship.
What no?
Lordship, I am coming. Lordship, who has identified me? A person.
Have you assailed that order of ours?
Yes, Lordship, I have seen where I have been, that a TIE parade has been taken place against me.
Did you challenge our order rejecting
No,
your
Lordship, because the circumstantial change is there. That was prior to submission of charge sheet. Charge sheet has been filed.
If he finishes, then I'll.
Yes. Then?
Next is, Lordship, after that, I'd like to produce all the evidences. Those are with me.
We will not like to see them.
But the thing is, Lordship, the quantity which has been seized, that has been seized from somewhere else, not from my position. Number one. Number two, I have been made accused in this case.
Sir, please understand, impress that upon the learned trial court. Trial court will be happy to acquit you. Impress those things. These are all factual aspects.
Factual aspects. But who am I, Lordship? I have been identified as Shanto. Who is Shanto? My name is...
Not so Shanto. Not
Yes.
so Shanto.
Shantanu. I have been identified as Shantanu. I am not Shantanu, Lordship.
Sir, we are not inclined, sir.
I am Dhiraj Haldar.
Sir, we are giving you a choice of not pressing, or we are going to reject it on merits. Choice is yours. We are trying to be nice to your client. So just take instruction.
I am not pressed,
I'm
Lordship.
ready with the entire.
Yeah, ready with?
Sir, আমি ready আছি ওটাই বললাম।
Oh, আচ্ছা।
To your detriment,
Yes.
but to your detriment, but not pressed, not pressed.
Lordship.
Post hearing, it was not pressed, lordship.
লিখে দাও একটা. After making submission for some time, learned advocate for the petitioner says that he does not wish to press this application for bail, paragraph accordingly. Dismissed as well. 60 অব্দি ডাকো, তারপরে অন্য ম্যাটার গুলো ডাকবে.
So I am for the petitioner. Lordship, I am for the petitioner. In this matter, Lordship, I am also relying upon Idul Mia's case.
On you. PhD on Idul Mia. Hey, Ishu, give the FSL report.
It's pending still.
Still pending. The petitioner was, date গুলো উনি বলবেন, শুনে নাও. The petitioner was arrested on
January 13, 2024.
Stop. Charge sheet without the FSL report was filed on
June 30, 30.
Stop. 180 days from the petitioner's arrest.
July
Expired.
13.
Stop.
13, 1-3.
The petitioner prayed for default bail before the learned trial court on
November 28.
November 28. Huh? Stop. His prayer having been rejected, comma, he is before us. Paragraph. While opposing the prayer for bail, comma, learned state advocate, in her usual fairness, comma, tells us that The FSL report is still not available. Paragraph. In that view of the matter and going by the ratio in our decision in the case of Idul Mia, citation diye dao, comma, the petitioner is entitled to default bail, paragraph accordingly.
Great.
Nahi. You want to oppose, but there is no one to propose.
No, my lordship, I am here for the petitioner.
Yes, Mr. Lochan.
Yeah, 2 years, 7 months, my lordship, already gone. My lordship has passed the last order 3 months ago, my lordship, to finish the trial. My lordship.
How
And
long
there
are you in
is no
custody?
2 years, 7 months, my lordship. 2 years, 7 months.
Last order?
Last order 3 months ago, my lordship, because they promised that they will finish the trial, but it's still at the same. Only 4 witnesses has been examined out of the 8, my lordship. And most important, there was a violation of section 52 was there, my lordship. The last order I have already given.
We specifically granted him liberty to renew the prayer for bail.
My lord, but my lord, last witness is going on, my lord, IO is going on.
No, that is already well.
Only last witness.
There
And
was
my
a-
lord, he
the direction.
prayed for time.
He prayed for time.
My lord, kindly see the order sheets, my lord, we have.
No, then best, Mr. Day, you file a status report. Status report giving all details.
My lord.
File a report. The petitioner says that while rejecting his prayer for bail by order dated September 23, 2024, this bench had directed Learned Trial Court to expedite the trial and conclude the same by the end of positively by the end of November, 2024.
My lord, don't take me amiss, my lord. Whether, my lord, outer limit can be fixed, my lord.
Cannot be. We wrongly did it. Nobody challenged it. What to do? It cannot be. After that, we have come to learn that we cannot do it.
My lord.
Failing which the petitioner will be at liberty to renew his prayer for bail. Stop. The paragraph, the petitioner says that the trial is still going on. Stop. He renews his prayer for bail. Stop. He says that he is in custody for 2 years, 7 months.
7 months. Yes, my lordship. 2 years, 7 months.
Yes. Mr. Lochan, we are adjourning this matter. We don't allow counsel to make submission from the car, from
No, my lordship, my apology here. My apology, my lordship.
Sorry.
It's just a missing of the time because
Sorry.
somewhere told me by 3 o'clock.
Adjourn, not today. Not today.
Okay, my lordship. My apology.
Yes.
Co-accused statement, same footing, another co-accused was granted bail by you.
সিডি নেই নট টুডে দিন সি এবারে ওইগুলো ডাকো ওই অন্য হ্যাঁ নিয়ে নাও আগে
Item number 1108.
1108.
First contempt. 1108.
No, we are first taking up original side matter.
Just seeking adjournment.
For the petitioner,
Yes. For the petition.
when the appellate side list is taken up, you say so, we'll adjourn it, don't worry.
1108.
No, টু আর থ্রিটা রিলিজ করবো বলে এনেছি স্পেশালি অ্যাসাইন ছিল ওয়ানটা কন্টেম্প তেজাস বলেটা আবার কি
না না ভাই বাইরে কিছু অ্যাথলেট সাইড
Petition.
Slaughtering.
My lord, contempt matter, my lord, I'm.
Slaughtering.
Yes, my lord, cow slaughter.
Cow slaughtering. File affidavit, Mr. Bandyopadhyay.
My lord, whether it has, in terms of your lordship's order, whether it is communicated to the present incumbent, I have not got the intimation from the present incumbent. Earlier, Chief Secretary is there, my lord, as respond number 1.
ও পান্তের নামটা ভুল আছে ও বাবা এ কি ঝামেলা অর্ডারে ভুল আছে অর্ডারটা কোথায় You see, the problem is, sir, in the last order, the name of Dr. Pant has been misspelled. So our department could not carry out the necessary correction. So that spelling has to be corrected today.
Lord, on the next day, I'll make a prayer for filing affidavits.
Likho. The name of the present Chief Secretary, comma, State of West Bengal, comma, has been misspelled as Dr. Manoj Panth, Pant, purota inverted comma bhetor dao.
On the alleged contempt.
Stop. The correct spelling is Dr. Manoj Pant, Pant.
Nurse.
Ki go, right, correct ki? Pant.
On alleged contempt nurse.
Ota abar inverted comma.
On the
Stop.
contempt nurse.
Let this correction be incorporated in the order dated December 19, 2024. Stop.
Thank you.
Paragraph, let the order dated December 19, 2024, as corrected by this order, be now carried out by the department. 1 week hence, kore di. Paragraph lists the matter once again. সামনে বৃহস্পতিবারের ডেট দিয়ে দাও
Fortnight hence then.
Fortnight.
23rd is a holiday, my lord.
Oh, 23rd is a holiday. 30.
Senior standing councilor late. পুরো হলাম লিখছি
My lord.
Released.
No, my lord, it may not be released because of the thesis. Your lordship had already delivered the judgment. The same issue is involved.
Yes.
That one of the Purti case and another my lord, judgment.
Correct.
Regarding heritage.
Yes.
Therefore, I am submitting my lord, lordship may be.
Absolutely no time, Mr. Ghosh. We are under so much pressure. You would not know. Those judgments will remain. They will
No,
bind.
that's right. That's right. That is the reason, my lord. I thought there's some pressure on the.
Go before the regular bench. Show those judgments. Show those judgments. Hey.
So, but this one, the first is Hillman is concerned. Hillman was the writ petition. The writ petition had not been decided because of the case before the division bench. Therefore, the writ petition was directly to be considered by the division bench. That was the issue.
Whatever it is, Mr. Ghosh, this is a specially assigned matter. Stop. Our present determination may not permit us to hear and dispose of this matter. Stop. Paragraph, let this matter stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction. Same in item number 3.
Item 3, my lord, I appear for the respondent. Lord, there's an order of your lordships of November 23rd. I'll take a copy now. May I, my lord, royal lordship's kind attention to this order once. Lordship was sitting with Justice Muralidharan. Release that matter from that bench to be heard by this bench, my lord. Your lordship kindly sees the order once.
Yes. Correct.
Yes,
But
yes,
now
that was released because of that.
we have no time. Very simple. Have you lost weight suddenly?
I hope not suddenly. I've been working on it.
Okay. Is this from England?
Oh, I missed my trip. I couldn't go. Grateful.
যশোর কেন ও যশোর করতে পারে আরেক জায়গায়
জানিস নি
কোন বইটা কোন বই
ওই ধরেছে ডাক ডেকেছে আমার ডেকেছে বলে দিস ইজ ডাকেন ডেকেছে
Number 1101. Review application.
In this matter, my lord, appearing on behalf of the alleged contemner number one.
এখন কন্টিনিউ রিভিউটা শুরু হচ্ছে বলে দিস ইজ দি
Yes, along with the contempt, my lord, contemner number one is
get
no
out.
longer in the post, my lord.
যারা না এখন ওটা তো হচ্ছে না দেখো
Incumbent has
আবার নিউ ইনকাম
We'll record an order allowing him to implead the new incumbent. Hey, CPANTA একটা order নিয়ে নাও, দেবজ্যোতি. Learned advocate for how many contemners? One?
Two.
So who has changed?
contemner number one, my lord, Manoj Pant, instead of Manoj Pant, my lord, Prabhat Kumar Mishra.
বাবা contempt application টা কোথায়?
This is a review.
না তার সঙ্গে একটা contempt আছে। এই যে লেখো CPANটায় লেখো learned advocate for the alleged contemnor says that the incumbent in the post of secretary, finance department, government of West Bengal, has changed. Stop. Mr. Manoj Pant has become the chief secretary. Stop. The present secretary, finance department is
Prabhat Kumar Mishra.
Mr. Prabhat Kumar Mitro. Stop.
Mishra.
Mitro.
Mishra. Mishra.
Oh, Mishro. MISHRA.
MIS.
MISHRA.
I'm only appearing on behalf of the respondent, alleged contemner number one, not two.
তাহলে advocate for the service respondent number one. Acha, stop. Leave is granted to the petitioner to add Sri Prabhat Mishro as respondent number 3 in the contempt application. Stop. Let necessary amendment to the cause title be carried out and service of the contempt application. You will accept service. You are representing.
already I have served I will serve him
You will be appearing for Mr. Prabhat Mishro.
আপনার নামটা
Stop. কি বললাম? Be carried out by learned advocate for the petitioner. Stop. Fresh service need not be effected since Mr. Paul, what do you write? Paul, learned advocate will represent Mr. Mishro. এইটা কন্টেম্পটা অর্ডার হয়ে গেল। এবার রিভিউটা শুনি আমরা, শুনছিলাম যেটা।
জানা না এখন আমি যখন বস না
1-5 কেন?
Well, on the last occasion, my lord, I commenced the argument, and my lord, halfway of my submission, and my lord, precise submission of my precise submission was that this is a case, my lord, Damdam municipality. Just short fact that my lord, a person was appointed by the municipality, and the post was not sanctioned, and not the appointment was got approved, my lord, by the authority. But here, his case, my lord, only that after the retirement from service, he came before this court to have the pensionary benefit. This is the only issue was before the single bench and also before the lawsuit, my lord. This honorable single bench, my lord, allowed the writ petition directing the authorities to pay the pension with reference to two circulars of the government, 7th May and 19th August. On that basis, my lord, relief was granted. When the matter, my lord, before your lordship, my lord, your lordship considered the entire issue, but your lordship on hearing held, my lord, that the two circulars are not applicable in case of the petitioner. But your lordship accepted the alternative argument which was advanced by my learned friend regarding the appointment. 53 3 and 53.4, that was discussed by your lordship, and that only alternative argument that 53.4, that by virtue of that provision, prior to amendment, that give the authority to appoint someone with reference to the post sanctioned post in the municipality. 1%, you consider 341,
Not exceeding 1%.
not exceeding 1 million of the sanction previous year. That was the consideration of your lordship. My submission or before your lordship with reference to that you accept, my lord, that your lordship observation, if that observations is, my lord, taken to be the correct in all sense, then the ultimate the conclusion that could not be arrived at because of the rules, my lord, provide for pension, that specifically says so, my lord, that the appointment which has been made, only the permanent employee of the municipality, my lord, should get the pension, but not in respect to the others. In particular, my it has mentioned the appointment which is made, 53, 54, 4 it has been mentioned. But I said, your lordship pointed out that it is 53, it should be 53, 4. But I do not know, my lord, that is the printing or something like that, because 54, 4 does not say about any creation of the post or appointment by the municipality. Therefore, my two-fold submission, this is a precise submission. If in, my lord, on accepting your, my lord, the findings of observation that it is an appointment which can be made by the municipality, then that, my lord, so far as the pensionary benefit is concerned, he is not entitled to get pension in terms of the particular, my lord, the pensionary rules. Even after that, my lord, I submit to your lordship, this appointment which is made, my lord, 53.4, my lord, that appointment, of course, my lord, that power has been given, that had been given by to the municipality, but that appointment cannot reach to the stage of, or it cannot be said to be a permanent post or the sanctioned by the appointment sanctioned by the government. If that be so, if you also consider, my lord, if that interpretation stands, then difficult would be, the complications would arise in the sense there would be no difference between the appointment under section 53.3 and 53.4. If you also meticulously read it, my lord, I have prepared a chart. If you also see the section, my lord, that has been quoted by your lordship, my lord, then there could be no difference. Then even the authority will be entitled every year to give appointment considering the sanction strength of the previous year, every year, 2 or 3 posts, 2 or 3 posts, 2 or 3 posts. In this way, if the municipality goes on by giving an appointment, then the sanctioned post, ultimately, the government prepares the entitled, the post is entitled, municipality is entitled to get such and such number of posts. Apart from entitlement,
who pays the salary of the employees of the municipality? Municipality or government?
Government.
Municipality 60%, we are the 40%.
I'm told, my lord, it is 60-40%, my lord, is given.
60 municipality, no?
Yes, 60 municipality, 40 forest, my lord, the government.
Therefore, Mr. Ghosh, unnecessarily the municipality will also not create posts because it will create financial burden for them also.
Of course, my lord, the financial burden, definitely, my lord, that, my lord, creates, that pure money create for temporary purposes, temporary posts. That is also a provision, my lord, I have seen in the Kolkata Municipal Corporation Act. But that cannot be ripened to the stage, my lord, consider that is a permanent sanction post. Even I take it, the post, my lord, has been, my lord, somebody has been appointed by the municipality. That is a temporary post, and, my lord, if that appointment ultimately government sanction, then the issue is over. The government ultimately, whether automatically it goes to the stage of the permanence of the post. But here in this case, neither of the two things had happened. Neither the post is the sanction, nor the appointment was approved. You can see once 53.3 and 53.4. Then you should find that in both the cases, appointment, two the provisions are there. Therefore, the status of appointment or the sanction or non-sanctioned post is definitely to be different. Otherwise, 53.3 and 53.4 would not have there. Therefore, I would মানে I've just, my lord, well, just for that pinpoint certain points, my lord, which I just am arguing to your lordship, my lord. 2 pages, you can see, my lord, the creation of the post, my lord, by the government or sanction of the post and the municipality. That what could, my lord, happen if the situation goes on. The medical officer, so he was appointed as a resident medical officer, RMO. The resident medical officer is a statutory post. There should be one medical officer under section 53(1) of the 1993 Act in the municipality. But 1953(1) speaks of, my lord, the statutory post. There I find, my lord, only one post is medical officer. There is no post, my lord, RMO. Not is a sanctioned post, not in the integral post. RMO, there is no post. The post of RMO was created without sanction and approval of the state government by the municipality. The creation of post without prior sanction may not be permanent post unless the sanction is obtained thereto from the government. Next, serial 4, the created post without prior sanction under section 53(4) of the Act 1993 cannot be equated with the sanctioned post by the government under section 53(3) of the said Act. Just what I am submitting to your lordship, the created post without prior sanction under section 53(4) of the Act 1993 cannot be equated with the sanctioned post by the government under section 53(3) of the Act. If the created post without prior sanction under section 53(4) is termed as permanent and a sanctioned post, there could be an absurd situation in respect of creation of post without prior sanction by the government almost in every year by the municipality, so the scope of interpretation cannot be stretched to such an absurdity having regard to the size of the municipal establishment and the categories of designation of officers and other employees of each municipality. The creation of post without prior sanction and the created post on sanction stand on different pedestal. The unsanctioned created post cannot have permanent status. The West Bengal Municipal Employees Death cum Retirement Benefit Rules 2003 apply to all the whole-time permanent employees under employment of the municipalities, vide Rule 1(3), but shall not cover an employee engaged for a limited time only under an agreement or engaged under section 53(4), 53(4) of the West Bengal Municipal Act on contract or commission basis or otherwise.
So he is a contractual staff.
My lord?
He is a contractual officer.
It's a, my lord, the temporary staff.
You are giving DA also.
No, DA.
Pay commission benefits were also excluded.
Well, I am submitting to your lordship, my lord, the benefits, over the benefits, I am not on that, my lord, right now, because whatever the payment has been made. But I am only on issue,
Unless he is a permanent officer, then how can you grant DA?
Well, your lordship has not held that. I could have understood because of the different reasons, your lordship holding to treat him as a permanent. I could have accepted. What my lord is now observing now, had it been done in a lordship's order, that because of these reasons, we are asking the government to treat him as a permanent. That's the one issue of the issue, one issue. But your lordship has said that 53(4), that post when somebody is appointed, therefore on that basis he should be given the pensionary benefit. He has not come for any status. He has only come to the lordship's court for direction of authorities to give him pension. If the pension, my lord, comes, only that pension, then my lord, automatically rules comes into operation and that devars him to get the pension under the rules. That could be done by your lordship. That because he has been allowed to continue for long period. I say, my lord, 53(4) does not say to continue a person for long period. That I accepted. I am not joining an issue with that. But this is not the finding either of the single bench or for the division bench. The division finding is completely different. I am on that, my lord, the reason. Therefore, your lordship, my lord, consider that on the face of the rule, whether on such issue the writ petition which has been presented could be maintained and, my lord, could be given direction by the court for, my lord, enjoying that benefit. Because otherwise, if that Your Lordship says that 53-4, that power in every year he could get an appointment and ripens to the stage of permanency because of granting the pension, automatically, indirectly it could be said. Then, my lord, it becomes a whole-time employee. Then the difficulties or the absurdity situation would come every time, my lord, the government functionaries. And it is a division bench order that will have to be accepted in all cases.
Very well.
This is my precise submission.
We shall stand correct.
Your submission is summarized here.
In short, my lord.
In short.
Well, so far as the status of the nature of the appointment is concerned, my lord, Lordship is well aware of the fact the position which was there prior to amendment of the West Bengal Municipal Act. It says it gives power to the chairman to create post and confer appointment. And the post was created by exercising such power, and the appointment was confirmed. And time to time, all the government related benefits were extended to them, including the pay commission benefits also. And also, my lord, the status of the writ petitioner who was given an appointment on a substantive basis. My lord, and it is very much there, as my learned friend has said, that he is not coming under 53. It's only about the medical officer which has been stated here. And so far as the other than 53(1) employees has been demarcated here, municipality has the power to create the post as per the unamended act. My lord, it's very much there. My lord, kindly see what is stated there in the unamended portion. That is, until the cadre of common municipal service for the state is constituted under subsection 1 of section 54 and subject to the provision of subsection 1 omitted with effect from 2nd September 2002. That's
on that consider you will pass that order. I'm unamended provisions. I am making submission on unamended provisions.
And the words, if the number of posts to be so created in a year for a municipality is more than 1% of the total number of sanctioned posts of officers and other employees in existence in the year immediately preceding, omitted by 2nd of September 2002. It says, my lord, the total sanctioned post, if it is of 300, then 1% comes to 3. And 3 posts can be created. The posts which are not coming under section 53(1, on strength of section 53(3), which is clearly stated that the post can be created by the municipality. And the proviso that is provided that number of posts so admissible for creation in a year without the prior sanction of the state government after the commencement of this act, if not created in that year, may be carried forward to the next year, subject to a minimum 1 and maximum of 10. This is also omitted from 2nd September 2002. So these provisions were there when the appointment was made. And my lord, section 53(3) clearly says that the board of councillors at a meeting subject to the norms regulating the size of the municipal establishment for each municipality and the categories or designation of officers and other employees of each municipality with their scale of pay as may be fixed by the state government from time to time, determine what officers, other employees other than the officers mentioned in subsection 1 are necessary for municipality, create posts of such officers, other employees, and fix the salaries, allowances to be paid and granted to such officers and other employees. As because it's a residential medical officer, it is coming under the other categories of employment. And so far as the rules which my learned friend has just shown, the pension rules, this came in 2003. And my appointment is of 1997, and the rules were placed before the Honorable Single Bench for consideration. This is not a new document which is being cited by my learned friend. The rules which my learned friend is citing at present
were appointed in
1997. Yes, I continued in that till 2015. 17 years of service I have rendered.
So do you say these rules do not apply to him?
Nowhere it's happened. Only kindly see the rules. It was placed before the learned single bench for consideration. This is not the discovery of new documents.
Very well. Anything more, Mr. Roy?
My lord, the maintainability of the review application, I have brought some judgments, my lord.
Give us the citations. Okay?
Yes, I will give the citations. My lord, kindly see the rules for once.
You want to deal with the judgments? Scope of review application, well known.
Under the guise of review, my lord, he cannot open the chapter and re-agitate the things once again.
I'm not legal question I have raised on one judgment.
Mr. Ghosh, I'll tell you very frankly, please go up Supreme Court, have a final verdict from the Supreme Court, because the scope of review is very limited.
Well, I'm showing one judgment. I'm missed you, my lord, show to your lordship, my lord. This judgment I rely on because, my lord, that well, I follow, my lord, that of course, my lord. On the issue of review, my lord, I just you know saying 3 paragraphs. 3 paragraphs I will read, my lord. The scope of review. Paragraph, my lord. 88 you can come to, my lord. Page 7 দিয়ে দেখতে কপি থাকে
80
88 2005 4 SCC 741 88 আমি 3 প্যারাগ্রাফ I rely on, my lord. 88 89 90 and, my lord, '93, 92 and 94. Well, I'm reading, my lord. You're saying, see, my lord. We are therefore of the opinion that the jurisdiction of the High Court in entertaining a review application cannot be said to be an expressive bad in law. Section 114 of the Code empowers a court to review its order if the condition precedent laid down therein are satisfied. The substantive provision of law does not prescribe any limitation on the power of the court except those which are expressly provided in Section 114 of the Code, in terms whereof it is empowered to make such order as it thinks fit. Order 47, Rule 1 of the Code provides for filing an application for review. Such an application for review would be maintainable not only upon discovery of a new and important piece of evidence, or when there exists an error apparent on the face of the record, but also if the same is necessitated on account of some mistake or for any other sufficient reason. Thus, a mistake on the part of the court, which would include a mistake in the nature of undertaking, may also call for review of the order, and application for review would also be maintainable if there exist sufficient reasons. Therefore, what would constitute sufficient reasons would depend on the facts of the circumstance of the case. That the word sufficient reasons in order 47 Rule 1 of the Code are wide enough to include a misconception of fact or law by a court or even an advocate. An application for review may be necessitated by way of invoking the doctrine of access curio, Nemian Gabebi. Therefore, the mistake, if the court feels that I'm trying to point out, there is a mistake in facts and also the law. If that is there, my lord, by sufficient, then there would be a miscarriage of justice. That is the reasons, my lord, I have filed this application for review before Lordship's Court, my lord.
What decisions you want?
Yes, my lord, of 2023, my lord. Just please, the paragraphs I am mentioning.
Just tell us the paragraph number.
Yes.
20. Wait a minute.
Paragraph 5. Paragraph 5. 5. Paragraph 5 of this judgment.
Very well.
Then, my lord, another 2020, my lord. These are all with the maintainability of the review application, my lord. Is all aware? Just highlighting the paragraphs. Paragraph 28 and onward. 28 and 29.
Yes.
And another, my lord. 2000 volume 6 Supreme Court cases 224.
Paragraph 58. Only, I think, add only one line, my lord. So far as the rules of 2003, which has been shown to your lordship, was a part of the proceedings before the honorable single bench. And the point which I highlighted by my learned friend was either not placed or agitated upon. So in the review petition, my lord, it's a preliminary point. This point cannot be agitated. This is a part of the proceedings. My lord, I have annexed that. And it is of 2003, and it comes into effect from 2003 onwards, and which has squarely no applicability in my case.
Very well. We'll.
That does not go. If the rules if the rules prepared prior to his appointment, of course, it will be applicable.
All right. Hey, hearing is concluded, judgment is reserved. Within a week or so, we will deliver. We don't want to waste court time in dictating in court. এটা আমার কাছে পাঠিয়ে দাও আমার হ্যাঁ কন্টেম্প্ট অর্ডার দিলাম কাকে একটা হ্যাঁ 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 এটাকে আগে ছাপি ওটাকে পরে ছাপা কন্টেম্পটা পরে ছাপা
Grateful.
We'll just come back in 5 minutes. Normally we rise at 3:15, but hey.
I was led by Mr. Banerjee and now you, my lord, figure standing counsel has come, my lord, my lord.
Mr. Amitesh Banerjee was leading you.
Earlier you were there, now.
Now who is the senior standing counsel?
Sishanda Bandyopadhyay.
Oh.
So he was here, my lord. He asked me to take time for 1 week time, my lord.
I put the responded to
Yes, but then you see, by keeping this review pending, we will not comply with the order also.
Yes. There is a contempt application also.
Also, my lord,
So let the contempt application be allowed. Contempt go to jail, then we'll hear your review. Adjourn for a week, but next week we are not going to adjourn it.
Next week your holiday, my lord.
Next week holiday.
30th, I mean 30th.
30th.
30th. এই একটা combined order করে দাও।
My lord, item number 1103, 1104,
1103 থেকে
1107 and 1117 and 1118.
1103 থেকে 1107, হ্যাঁ? তারপরে 1113
1103, 1104, 1105, 1106, 1107, and then 1117, 1118.
On the prayer made on behalf of the review petitioners, let these matters stand adjourned and be listed again on January 30.
Item number 1108.
We are coming back. 1108 on the prayer made on behalf of the petitioner. Adjourned for a week.
Start হচ্ছে 1144, 1145,
1144 থেকে 46 অবধি।
হবে না fixed. Mr. Mukherjee is appearing. No?
My lord, Mr. Mukherjee is leading in this matter, in all the matters.
Number 1144 to 1146.
1144.
1144 to 1146.
Mr. Mukherjee is appearing.
My lord. Fixed আছে।
Can I play 1114 to 1116? When do you want it?
Can I pray one thing, Malak? Let it be adjourned for a week for now.
Yes, ma'am.
Let Mr. Mukherjee come. After
Yes.
that, my lord fixes up a time
Correct.
and date.
Correct.
Yes. So let it be adjourned for a week for now.
He appears for the petitioner in all the three matters.
My lord, my lord, all the three matters.
On the ground of indisposition of learned senior counsel for the petitioners in these three matters, adjournment is sought for. Paragraph, let the matter stand adjourned for a week.
I'm grateful.
No, week means next
Thursday.
Next Thursday is holiday. So adjourned for a week, it will come on Friday.
345. I'm grateful to you.
It will come, it will, Mr. Nondi.
মিলন্দ আসলে তারপরে ফিক্স
একটা টাইম ফিক্স করো।
Time and date.
আর এটা 345 আছে তো দেখেছো 1133 টা দেখো না অন্য ডেট আছে ওটা ঠিক আছে ডাকো যা ডাকবে
হ্যাঁ 34 আমি আছি করতে হচ্ছে না না হ্যাঁ ঠিক আছে কোনো
এটা কি নেবে Rasulullah, take up the contempt matter.
হ্যাঁ
Oh, continue.
কি ডাকছো না কেন
I am for the petitioner, my lord. I am for the petitioner, my lord.
Take to appear on behalf of the municipality. My lord, the petitioner is no more, my lord. The death certificate is with us. Substitution করেছেন?
petitioner is no more you have no instruction
My lord, I am kindly.
petitioner is in another world
No, no, my lord, kindly, your lordship, kindly see at page 37, my lord. Your lordship's order was there. The legal year of the petitioner shall appear before.
sir if the petitioner is dead how does this application survive
No, my lord, kindly, your lordship's order. Your lordship was kindly see you. One second, kindly see, my lord. Page 39, my lord. Page 39, my lord. Page 39, second paragraph, my lord. Learned advocate for the petitioner shall furnish address of all the legal year of Kaminibala to learned advocate for the alleged continuance by 25/4/23. the Board of Councillors shall issue notice of hearing to all the legal heirs of Kaminibala. Even in spite of receipt of notice, if one or more of the legal heir fail to appear at the hearing, the Board of Councillors will still proceed and dispose of the matter. Now, on the basis of your Lordship's order, I personally present before the Board of Councillors on 6/6/23. Hearing was concluded and I have submitted written notes of argument before the Board of Councillors. That is at page, my lord, 47, as page 47, with all necessary documents.
Yes.
And thereafter, this matter was not disposed of as yet. Therefore, this application is filed before your lordships.
Yes, Mr. Chakraborty.
My lord, he requires to, my lord, the substitution is required to be made, my lord. Even if contempt application survives.
That is true.
So, my lord, it is appearing in the name of a dead person.
But what your instruction, what we recorded on the last occasion,
My lord, as it,
because Kaminibala Bar has passed away,
Lordship,
therefore hearing could not be granted.
to her, as was directed by this honorable court. Accommodation is paid for on behalf of
Now
the
hearing was granted, notes of argument have been filed in June 23.
Lordship.
No order has been passed.
So, my lord, in that case also,
Why
my
we
lord,
should not send your client to jail? Yes, this is disobedience. This is disobedience.
no, my lord, my humble submission, my lord, substitution is required to be made, my lord.
First get the legal heir substituted.
Yes, my lord.
This application does not survive.
Yes,
Please
my lord.
try
This
to
is my
understand, sir.
humble submission, my lord.
The sole petitioner is dead.
No, on the date of filing of the earlier petition before your lordship,
Since honorable court
your
directed
lordship-
once again.
Your lordships was pleased to pass this order.
এই petitionটা তো legal
It's not.
sole petitioner মারা গেছে।
Since, my lord, it is reiterated by this honorable court, I will take instructions so far that part is concerned. But
you've still not followed what we are saying.
I have understand, but your lordships has specifically passed order, even in spite of receipt of notice. If one
Conduct this case. Who will conduct this case?
who has authorized my learned friend, my lord? A dead person.
Who is instructing you today? Kaminibala Bar.
No, legal heirs, my lord.
Where are they? We don't know. They are not before us.
Substitute.
বুঝতে পারছেন না উনি।
Then I shall
একটু
file
বুঝিয়ে দাও।
Then I shall file an application for
Correct, sir.
substitution, my
This is
lord.
what we are trying to tell you.
Yes, my lord.
Adjourn for 2 weeks. Take the sole petitioner is dead. Stop. The legal heirs of the petitioner need to be brought on record. Stop. Paragraph list, adjourn let this matter stand adjourned for 2 weeks to enable learned advocate who was representing the petitioner, since deceased, to take appropriate steps in the matter.
Yes, madam.
In the meantime, Mr. Chakraborty,
I'll take.
I shall file it by 2 weeks, my lord.
you can file it whenever you want. We are adjourning for 2 weeks.
Yes.
2 weeks. দিয়ে দেবে 30 তারিখ।
My lord, I am for the petitioner. My lord, in this matter, my lord, Robindranath Dotto is appearing for the contemptor, my lord. My lord, for his personal difficulty, he, my lord, has not come today. My lord, I am praying for 1 week adjournment. My lord, in the meantime, my lord, on 6th of January, inspection was held. 10th of January, hearing was concluded. But order has not yet been, my lord.
What was our order?
Well, order was passed on 17th of May 2023, your lordship.
File দাও।
At page 20 of contempt application.
Where is the order?
Page 20, my lord. Annexure P2, order dated 17th May 2023. And now we are in January 2025. Well, matter relates to the illegal construction and executive officer was called upon to file affidavit. Yes.
Yes. Now it appears that inspection was held, as he is saying.
My lord, inspection was held. Thereafter, a hearing was held. Till date, my lord, they have not passed any order, at least not communicated.
We are keeping this after 2 weeks because next Thursday is a holiday.
Yes, ma'am.
On 30th, we are recording an order. Affidavit compliance report should be filed. In the meantime, order should be
communicated to them.
Order should be passed by the municipality. Learned advocate, you're appearing for the alleged contempt,
Yes, yes.
Learned advocate for the alleged contempt says that on January 6, 2025, fresh inspection of the property in question was held in the presence of all concerned parties. Stop. Hearing was granted to the concerned parties on January 10, 2025. Stop. A reasoned order is yet to be passed. Paragraph. Learned advocate for the petitioners is in agreement with the submissions made above, submissions made on behalf of the alleged contemnor. Paragraph. Lists this matter once again on January 30, 2025. Stop. In the meantime, a reasoned order should be passed by the alleged contemnor and compliance report should be filed in court on the next date. Communicate to your client immediately. Otherwise, he'll go to you know where, which is the nearest jail.
Thank you.
My lord, in this case, my lord, really not only my client but also I'm in difficulty for the reason that I have carefully perused the order of the single bench and also of a lordship. And whatever action has been taken in the process of compliance of a lordship's order, my lord, that I have presented to lordship. I have not said anything, but I find possibly they are also, my lord, not correct in the process of doing the thing in terms of a lordship's order. Therefore, my lord, I am also, my lord, could not give the advice, my lord, how it is to be done in the present scenario. My lord, what has done your lordship just pointed out when I seek your lordship or also any directions of your lordship, because I want that the order to be complied with. On the division bench order is there. Your lordship can see
Only
the
Mr. Mujumdar, only one thing. Mr. Shaumo Mujumdar is not here.
Yes, Mr. Shaumo Mujumdar was the private respondent against whom there was a peripheral contempt. I mean, which I am not seriously pressing that much.
No, but some direction Mr. Ghosh is asking.
Yes,
it may have some effect on his client.
Yes, that may be.
His client has accepted the order of the Honorable Division Bench, not gone up. So whatever comes is
very good advocacy, Mr. Banerjee. But they have been appearing all throughout.
Yes. So if your lordship wants to keep it even, even say
30th, because next Thursday is a holiday.
Thursday is a holiday.
Well, I think there may be necessary certain directions because my clients, one also I do not find how to advise them right now to comply with your lordship's directions.
Milord, the actual advocacy is here. It's an attempt to have the order modified in content.
No. Why?
I don't know what to do, my lord.
This is what seniority is all about.
This is what seniority is all about.
Experience.
How to get an order modified in content by feigning helplessness. Not him, his clients.
The court, impressed by this simplicity, this bona fide approach, will grant him anything.
Anything. And then that will be a modification of the original order and the content will go. And the next day, Mr. Ghosh will be at his aggressive best, saying nothing remains in the content. That's why he's beaming.
The alleged container numbers 3 and 4 are not represented today.
I am for the 3 and 4, madam.
Oh, you are there. Very good.
I have led by Mr. Mojumdar, my lord.
Oh, what were you doing? Silent.
Yes.
Then what should we do? Tell us.
Mr. Ghosh should take instructions. Mr. Ghosh should do something in the meantime so that I don't have to pursue.
Things, my lord, what is to be done, my lord, may not, my advice may not also be correct because of the present scenario, my lord, after.
Let's come to the nub of the dispute. My lords took up, my lord, the matter in division bench and directed that once a construction has been pulled down under 400 subsection 8 and reconstructed, there can be no question of regularization. Please take steps. They went and regularized it.
Mr. Ghosh, is there any ambiguity in our judgment?
But there is, because of the reasons I submit, I come to an opposite part of Ulysses order.
Page 25, page 63.
Page 66.
Yes.
My lord, Ulysses kindly, Ulysses quoted the order of the single bench at page, my lord, at page 51. Ultimately, it appears, my lord, that initially the action was taken under section 400 subsection 8. Then the court, my lord, after that said, at page, my lord, 52, 51 bottom, my lord, under such circumstances, this court is the opinion that the corporation must proceed afresh in accordance with law with regard to the unauthorized construction which had once again detected at premises number such and such. Corporation requires police assistance. Such assistance shall be provided. The application for regulation which has been filed by the respondent of 5 and 6 shall also be decided simultaneously in the proceeding. Such direction shall not be construed as an observation on the right of the said respondents to get such construction regularized. The entire exercise shall be completed within a period of 2 months from the date of inspection. When the appeal was taken out, the process had all been started to act in terms of that direction of the single bench. Then ultimately, Your Lordship, my lord, considering that entire issue, Your Lordship passed directions in page, my lord, page 66 at paragraph 4.
24.
24. Well, we are constant to set aside the impugned judgment and order. Then you also see respondent of 4 and 1 to 4 are directed to consider the complaints of the petition appellant in accordance with law. The respondent numbers 5 and 6 are directed not to make any further construction at premises number such and such except in accordance with the sanctioned building plan. And the KMC authorities are directed to take appropriate steps against the unauthorized construction which was once detected, demolished, and subsequently reconstructed at the behest of the respondent number 5 and 6 beyond the sanctioned plan in accordance with law within 8 to such and such. But submission of before Lordship, my lord, that action has been taken by us under section 408 that the entire construction to be demolished, unauthorized construction to be demolished in terms of the section without giving any hearing. Now, if your Lordship, my lord, says that set aside the judgment, then automatically it appears to me the order of ours 408 will survive.
Very well.
Survive, according to me. But then you will say it again, the respondent number 4, 1 and 2 directly consider the complaints of the retribution appellants in accordance with law. That, my lord, the case, my lord, the difficulties on the part of authorities, they, my lord, proceeded the matter to be heard and actually, my lord, the matter was placed before the special building and his regular certain orders have been passed. And my lord, matter was again placed before the mayor in council, he approved the same. That cannot, in my dispute submission, that is also my understanding, that if that directions part could not be there, because once it is set aside, then automatically my order under
Complaint was pull it down. 400
was-
subsection 8, so therefore demolish.
Initially demolition, then again
Reconstruction.
No, demolition, reconstruction was certain part.
Mr. Ghosh, no, Mr. Ghosh will have to read the judgment pilot in its
I'm
entirety.
submitting.
Today, my lord, Mr. Ghosh started by saying that bona fide he could not appreciate.
I'm submitting that.
Mr. Banerjee,
That if it
you
is
have a
survives,
chair
I will
behind-
demolish.
Sit.
But if it survives, my lord, if it is true, I can demolish the entire part.
Mr. Ghosh,
There is no question of
when we say consider their complaint in accordance with law, 400 subsection 8 is also law.
no, of course.
If according to you, this is a case which warrants exercise of power, then you do it. We have not, there's no ambiguity.
No, question about then, my lord,
If you want, we
automatically,
can clarify it.
you will clarify that, then automatically that order survives. If the order under 408 survives,
yes,
then there is no even to consider his complaint, because when LOC is setting aside that further hearing regularization part, if that be the intention of the court and that has been recorded in the order, therefore automatically, my lord, I could have understood that LOC has set aside the order.
we will clarify that this direction of ours does not require initiation of a proceeding under 400 subsection 1.
When LOC make it clear, my lord. But that is on, my lord, I say.
Yeah.
No, I said, my lord, that automatically survives. But they, my lord, proceeded that regarding the consideration in accordance with law, that possibly, my lord.
Read it as a whole, and directed to take appropriate steps against unauthorized construction, which was once detected, demolished, and
No, that is, my lord, one part. That is one part, my lord,
beyond the sanction plan.
No, that is one part, my lord. That is, my lord, the process, my lord, they, my lord, demolished and that restored.
In all fairness,
As a whole, not as a whole.
That
No, not only that part. He doesn't want only that part. He wants that whatever the unauthorized construction detected by us and taken action under the 408 to be pulled down.
But Mr. Ghosh,
Therefore, my lord, I'm accepting. That is also my view. That when a lordship is, my lord, setting aside the order of the single bench, my order survives.
You are now a senior advocate. Sit down. No interruption.
No interruption.
Then my order survives, and that should be done. Therefore, my lord, since in the meantime,
You may now advise your client accordingly. We'll post it on the 30th. We do not want to pass any order in the absence of Mr. Mujumdar.
no, you know, I will just seek a clarification that the subsequent action, whatever is taken after the decision taken by our smaller 408, and since it has been set aside, therefore further whatever steps have been taken, that cannot stand.
We have
That
told
will
you that.
clarify then automatically.
Clarified.
We are not asking any order now.
Well, actually, that I want, my lord. That I can, my lord.
You advise accordingly.
But I already advised that.
Open court we have discussed.
Mr. Ghosh, my lord,
Since, my lord, there are two issues are there. Mayoral Council, once, my lord, took the decision. Then again, my lord, after that single bench order continued and he approved the order of the special building, that is to be set at not.
special
That is
officer
that is
Meeting's order came after your lordship's order. After your lordship's order.
Hey, Yashu,
हाँ,
having heard learned counsel for the parties,
ये दिन ना.
we only clarify that our direction in paragraph 24 of the judgment and order dated July 28, 2023 is not to be construed as a direction for initiation of fresh proceedings under section 400(1) of the KMC Act, 1980.
That's it.
Subsequent fresh proceedings and order kindly set aside.
That's it.
He says.
Yes,
the subsequent. That's a subsequent.
The direction was on KMC to take steps against all unauthorized constructions in accordance with law. In accordance with law, be it 408, be it whatever.
No, subsection 1, my lord had said there is no scope of granting regularization. Therefore, after this, my lord, it was a mandamus for demolition. My complaint was, please demolish. My lord said, please consider it in accordance with law. In the judgment, my lord has clarified in detail.
No direction for initiation. Huh?
And the actions were taken, my lord, under say 401.
One, kindly quash them.
We have set aside the order.
No,
No.
this is subsequent.
After the order, my lord.
After your lordship's order, a 400 subsection 1 is made by the
Can we
special
do that in a contempt jurisdiction?
It's expedite, it's
Because of your lordship directions that is set aside and automatically survives, therefore subsequent the proceeding which has been that cannot stand.
This is ex facie contumacious, so this can be set aside in contempt jurisdiction itself. It would have been a fresh cause of action had it been legal.
That we will do after hearing Mr. Mujumdar.
Yes, my lord.
Won't be fair. His junior is here. List the matter once again on January 30.
Would your lordship kindly record an expectation that the corporation should comply with the order? After all these frauds, if they don't do it, something seriously wrong.
comply করার কথাই বলছি।
Legal consequences of setting aside of the order of the learned single judge will follow. Stop. KMC is directed to act accordingly. Act accordingly.
And would your lordship direct them to file an affidavit of compliance on the next day? Let us see what they feel is compliance.
I have explained my
paragraph on the adjourned date. Let KMC file a report. KMC file a report.
Okay, that will do. Yes, that keeps it even.
30th.
Yes, 30th.
সবই থাকবে।
No.
চলো 344 করাতে হবে। One and two. But I am appearing respondent number 11 in person, but I am filing my affidavit. Your lordship.
But I am for the contender number 1 and 2, the two additional session judge.
Malad, it is a fit case to issue 340 because they deliberately made wrong allegation against me, Malad. Kindly see paragraph 4 of the.
You are for who?
I am appearing in person.
Because Milord, lordship will see Milord
in person.
Lawyers and all, everybody's
dress code should be followed.
Respondent numbers 5 to 9 are here.
Malad, the rule was issued in the morning. The 5 to 9 has come up and gave out a power to me. They are in person. They have been present in the court, Malad.
They are present in
Yes,
court.
Malad. I can bring them because one is a complainant, Malad, where the ST case was going on, and four were the securities which gave out on the bail.
Sir, do you wish to answer the rule by filing an affidavit?
Yes.
Do that. Mr. Boshu Mullik is appearing for?
I am appearing for Milord, two additional session judge, Milord, Dilip Kumar Das and Sanjay Kumar Sharma. Unnecessarily, Milord, the order has been passed. When the order was passed, there was no stay order which has been granted by his lordship. The matter was dismissed for default. That was not bring to the notice to the court, and court has, on the basis of the documents, court has passed an order. And if his lordship takes the order of Justice Chakraborty sitting with Justice A, Milord,
Judicial officers have been
unnecessarily been implemented as a
not the date for hearing. I should not open my mouth.
Yes, Milord,
But
15
I
is
am
there.
to say one thing. I'm to say one thing that my lord, that all the persons, my lord, that the honorable court's order have been flouted deliberately, my lord.
Milord, if
I
lordship,
show
I
at
will,
the
I
hearing
will,
hearing,
I will take to his lordship
each one
kindly.
of them,
What was the order?
my lord, whether today we are here at least to hear out the matter. My lord, that the particular order of the honorable court was to the way. That means the honorable justice, the then honorable chief justice Thatkathil V. Radhakrishnan, with honorable the sitting justice now here, the presiding judge, honorable justice means our honorable justice Arijit Banerjee. Now, my lord, that the companion justice and my lord the bench, my lord, was pleased to pass that the matter will be heard out properly, and till then there will be stay, and warrant will not be executed or whatever may be. Knowing fully well and in presence of all the persons, your lordship will kindly see the order dated 17/9. There it is clearly stated that all the persons they have appeared there, and in their presence and within their hearing. And after hearing all the things, they have come, the honorable court passed the order that we will hear out the matter, and
report was called for. Therefore, it was incumbent upon the attending person, and it was the duty upon them at least to communicate the concerned judge. And at the same time, on the next date, that means that on the scheduled date, as was fixed on 19th, we appeared there, and they did not care for all these things. That yes, you have brought the order from the Honorable High Court. We do not care for it. Warrant is issued. What type of audacity?
No,
That
my lord.
means
At that
administration
point of
justice,
time, when the order was
that
passed,
is-
my lord, the matter was dismissed for
open my
default.
mouth anymore.
What?
I will
Lord,
swear.
kindly
take
next page 30.
Take them to their duties.
Page 30.
Why affidavit?
Affidavit for respondent number 3.
No, no.
Yes, we have.
এই লেখো লেখো লেখো
Respondent in person, my lord. Respondent in 11.
affidavit in opposition filed by the respondent number 11 be kept with the records. Paragraph pursuant to service of rule, comma, the respondent numbers 5 to 9 have personally appeared in court. Stop. Their personal appearance is dispensed with for the time being upon their undertaking to be present in court as and when called for, as and when directed. Stop. They will be at liberty to file affidavits in opposition, affidavits in response to the rule. Capital R debe. Any other respondent?
My lord, I gave out the respondent number 2 and 3, my lord. The opposition has submitted.
You are for 2, 3 and then 5 to 9.
5 to 9 also. Today in the morning they gave out 5 to 9, my lord.
Stop. Affidavits filed on behalf of respondent numbers 2 and 3 also be retained with the records. You are who?
But I was told by the LR office that I will appear for 1 and 2. What is happening, I don't know.
I am for the 1, 4 and
Paragraph. Mr. Basu Mulli, comma, learned advocate is representing the respondent numbers 1 and 2. Stop. ওদের কি affidavit file করবে?
Lord, judicial officers, my lord, is glaring from the order, my lord. Their name is unnecessarily being added.
Their affidavit is not necessary immediately.
Lordship. From the records, my lord, I will show that.
But my lord, I have submitted for the respondent number 2.
We have recorded it, sir. তাহলে 2, 3 হয়েছে. You are for whom? 11 হয়েছে. 1?
1, 4 and 10.
1.
কি আরম্ভ হয়েছে আমি বুঝতে পারছি না।
Earlier occasion, my lord, I have
Who is 1?
Judicial officer.
Mr. Basu Mullik is appearing.
Earlier occasion, I have.
You to ashish Dilip person is to 1 number.
I have been instructed by the LR to appear.
Government has appointed.
We are not taking it on record. You sort it out. Go to the LR's office, sort it out. What is this? Mr. Basu Mullik is senior to you.
Then, my lord, 4 and 10, my lord.
4 and?
10.
You are appearing 4 and 10. Affidavits filed on behalf of our shop para kore debe. Respondents 4 and 10 we also kept with the records. Paragraph. The petitioner.
5 is not still appearing, my lord.
Huh?
5.
Yes, 5 to 9 has
Appeared.
5. No, Sushma Phadikar.
Yes, Sushma Phadikar is there. The complainant he has attached a complainant.
appeared. The petitioners will be at liberty to file their affidavits in reply to the aforesaid affidavits in opposition. How many time? How much time? 2, 3 weeks.
Reply, my lord.
To all these affidavits.
My lord, that whatever, my lord, the affidavit in opposition will be there, my lord. I will give reply, my lord, very frankly, my lord, that the after 26th, my lord, after 26th of
26th of
January.
How long? Tell us. You want 2 weeks?
My lord, that is 3 weeks, man.
3 weeks. Within 3 weeks from date. 3 weeks is enough or 4 weeks?
No, my lord, 3 weeks is more than enough.
Within 3
At
weeks
least with
from
the
date.
scenario. No.
Paragraph lists the matter after 4 weeks.
I'm grateful, my lord.
Yes.
Enough.
It's a division bench. না নিও না 4 আর 10 টাই 4 আর 10 টা রেকর্ড করো না তো এক কপি করে দিয়েছি 4 রেসপন্ডেন্টস 4 আর 10 যেটা বললাম ওটা রেকর্ড করো না অ্যাপিয়ারেন্স করতে পারো নিচ্ছি না তো হ্যাঁ বুঝেছি সব বুঝে জ্ঞান পাবি
It is a fit case to issue my lord 340. And he is wasting the valuable time of the. Oh,
Yes, Himango is you.
Yes, Lord, I am but the contemner, Lord.
What happened in Himango?
My lord had directed, my lord said directed the
status
report, municipality to remove unauthorized structures on the
What is
footpath.
that?
The status report.
The status, it's the second status report.
You have got a copy?
I've got a copy. Now, my lord, municipality says that we went on a removal of encroachment drive and we were resisted by local people, including political outfits, and therefore we can't execute. Paragraphs 11, 12.
Oh, I see. Yes. What is to be done now, Mr. Banerjee?
Please direct, my lord, the superintendent of police, or if it's a commissioner, then the commissioner, to provide adequate force to police force to assist them to execute the orders of court. If this is taken, my lord, to be a valid alibi not to comply with orders of court.
You don't wish to file any response to this?
No, it's absolutely clear. They say that we have been there. There's been local resistance. Now, local resistance, my lord, the superintendent will take care. Superintendent of police দেখো না
কমিশনারেটের আন্ডারে কিনা দেখিনি বারাসাত কমিশনারেট না
কমিশন
তাহলে বারাসাত
এসপি আছে
not a particular solution.
Then the superintendent of police, my lord, is not part of a commissionerate. He should personally ensure compliance of the order. This according to
This is your duty to evict.
My laws have on different occasions directed.
Yes, Mr. Banerjee, court orders must be enforced. That is axiomatic.
We are ready to execute.
Point is,
they don't have enough executive force.
Point is, by avoiding law and order problem,
Yes.
if possible.
Yes.
Now, they have categorically, the municipality says that it will escalate tension in the area. Huh?
That's why, my lord, if the jurisdictional SP, why I'm saying superintendent of police, he's the most responsible person of the area. He will know best how to tackle the situation, maybe put in a temporary 144 or temporary freeze and tell the police to execute and then come out. It will be very peaceful. Like slums sometimes, my lord, are evicted from railway, encroachments are evicted. They first of all...
Have you made the SP a party?
No, I haven't. But your lordship can, lordship can, my lord, if your lordship, my lord, on my prayer, add him, because in content, my lord can pass whatever orders are necessary for compliance. এটা কি সুপ্রিমকোর্টের পুলিশ কি দেখো তো পুলিশ বারাসাত বলে মেরে দেখো না একবার
Status report in the form of affidavit affirmed on December 9, 2024, filed by the chairman of the Barashat municipality, is taken on record. Paragraph. The crux of the report is that the municipality has been unable to execute the court orders for removal of illegal encroachment by reason of resistance from the side of the encroachers. Stop. Paragraphs 11
and 12 below.
To 11 and 11 to 14 of the said report read as follows. ঠিক আছে? Paragraph. Orders of court must be enforced. Stop. Otherwise, the rule of law will break down. Stop. So long as an order or direction of a competent court stands and is not interfered with by a higher forum, comma, the same must be executed. Stop. If the help of the administration is required for execution of such order, comma, it will be the bounden duty of the administration to extend such assistance. Paragraph. We direct the superintendent, we suo to add the superintendent of police, which district? Barashat.
Barashat. Not 24.
Not 24 Parganas.
Barashat police district.
As a pro forma respondent in this contempt application. Stop. Let necessary correction in the cause title of the contempt application be made by learned advocate for the petitioners. Paragraph. We direct the pro forma respondent, i.e., the superintendent of police, comma, North 24 Parganas, comma, to ensure that the relevant orders of this court are executed / implemented in the manner that he may deem fit and proper. Stop. We leave it to him to decide the manner of execution of the order. Stop. The brass tacks is that the orders must be executed. Stop. Otherwise, it will amount to supporting and perpetuating illegality. Stop. Paragraph. Learned Registrar General of this court is requested to forthwith communicate this order to the Superintendent of Police, North 24 Parganas, along with our earlier orders passed on this contempt proceeding and the status reports filed by the municipality. Stop. Let this file be placed before the Learned Registrar General so that the status reports and all orders of this court are made available to her. Stop. বুঝতে পারছো কি বললাম? সই হয়ে গেলে paragraph, the petitioners shall render all cooperation and assistance to the pro forma respondent herein as he may require. List the paragraph, list the matter once again after 4 weeks.
4 weeks.
And then shall also cooperate with.
Why only petitioners? The petitioners
and the respondents.
And the respondents. Next, list the matter after 4 weeks. Date ta diye dio. On that date, the superintendent of police, North 24 Parganas, shall file a status report before us.
Deeply obliged.
পুরো ফাইলটাই দিয়েছেও এই কোর্টের যে পুরোনো অর্ডার গুলো আছে এই অ্যাপ্লিকেশনে প্লাস স্টেটাস রিপোর্ট দুখানা আছে বোধহয় যেটা মিউনিসিপ্যালিটি ফাইল করেছে আজকেরটা এবং আগে আছে বাবা গুলিয়ে গেলে আমাদের কাছে এসো আমাদের কাছে এসো না গুলিয়ে গেলে মিস্টার অরিন্দম ব্যানার্জির কাছে যাবে
May I have my lord kindly read my lord 1121, item number 1121 of today's list, my lord. This was, I have already mentioned in earlier occasion, my lord. And this was going down a bit, my lord, for the inclusion of the new matters. And this is the third time content application for execution of the order dated 28 February 2024, my lord.
Reasoned order has been passed.
My lord, reason order has not yet been passed, my lord, and that has not been communicated. And I am remediless to.
You know, you had disposed of the
further, my lord.
content application
And
earlier.
The successive contempt, my lord.
I do not know what the content
Anyway,
application.
sorry.
My lord, if this can be
434.
fixed, my lord, in the
It will be there in the list.